न हि ज्ञाने सदृशं पवित्रम इह विद्यते तत्स्वयं योग संसिद्ध कालेनात्मनि विन्दति। अर्थात इस संसार में ज्ञान के समान पवित्र करने वाला निसंदेह कुछ भी नहीं है। उस ज्ञान को कितने ही काल से कर्म योग के द्वारा मनुष्य अपने आप में ही आत्मा में पा लेता है। Which means, in this world, there is nothing so sublime and pure as transcendental knowledge. Such knowledge is the mature fruit of all mysticism, and one who has become accomplished in the practice of devotional service enjoys this knowledge within himself in due course of time. With this verse of Gita, I extend a very refreshing good morning to everyone present here. A very warm welcome to the respected chief guest, our Honorable Director Sir, Honorable Speakers, respected faculty, and all the participants. With great excitement and enthusiasm, we extend a very warm welcome to each and every one of you to the workshop on intellectual property rights, organized under the Department of Electrical and Electronics Engineering and sponsored by the Council of Science and Technology, Uttar Pradesh. In this contemporary world, when our own intellect and ideas are almost equivalent, or even so, much more valuable in comparison to the worldly possessions, it has become more important than ever to emphasize on its protection and legalization. This is Rajanya Srivastava, and alongside my co-host, Ms. Anshika Bhagat, we are honored to guide you through this enlightening journey over the course of this workshop.
This workshop aims to provide participants with a comprehensive understanding of intellectual property rights. These are legal rights that protect creations of human intellect, such as inventions, literary and artistic works, designs, and symbols. These rights grant creators exclusive control over their intellectual assets, enabling them to benefit financially and regulate their use. As a part of academia, understanding IPR is essential for safeguarding and leveraging creative, innovative endeavors in various fields. Proceeding with the session, it is my distinct honor and privilege to introduce Professor A.S.K. Sinha, our esteemed Director Sir, whose leadership and vision has been instrumental in shaping the trajectory of our institution. He is luminary in the field of technology, whose expertise and dedication have left an incredible mark on academia and beyond. Please give a round of applause for Sir.
Sir, please come on stage. Okay, sir. Moving on, it is my distinct pleasure to introduce to you the chief guest of the session. She is currently working as Joint Director in the Council of Science and Technology, Uttar Pradesh. She is heading the IT Division and IPR Division in CST, Uttar Pradesh, and also in charge of the Summer Research Fellowship there. She is an alumni of the prestigious BITS Pilani and IET Lucknow, and has done her PhD from Dr. APJ Abdul Kalam Technical University. Her research areas includes formal verification and validation of recovery protocols in message passing systems. She has several publications in reputed journals. Please give a huge round of applause for Dr. Pooja Yadav.
Moving further, please welcome our Head of the Department, Electronics and Electrical Engineering, Dr. Umakant Dhar Dwivedi, Sir. Sir is an esteemed accommodation and a brilliant example of brilliance and kindness and passion.
And also, please give a huge round of applause for Dr. Amrish Dubey, Sir, Coordinator of IPR Workshop.
Please welcome on stage As we have gathered here today to inaugurate our workshop on intellectual property rights, let us symbolize the beginning of our journey with the lighting of the lamps. आज के दिन की शुरुआत माता सरस्वती को याद करते हुए सरस्वती वंदना के साथ हम सभी करते हैं। मैं दीप प्रज्वलन हेतु माननीय निर्देशक महोदय, माननीय मुख्य अतिथि को स्टेज पर आमंत्रित करना चाहती हूँ।
Thank you. Proceeding with the session, I'd like to request our esteemed director, sir, to please present bouquet to our chief guest as a token of welcome.
Proceeding further, I would like to invite HOD sir to come on stage and present a bouquet to our esteemed director, sir.
Thank you, sir. Now, I am pleased to extend a warm invitation to our esteemed head of the department to share some words of wisdom with us. Sir.
Good morning. Honorable Director, Professor A.S.K. Sinha, sir, our esteemed guest, Dr. Pooja Yadav, deans, head of the departments, and faculty members, participants, volunteers. It is with great pleasure and anticipation that I welcome you all to the inaugural session of the workshop on intellectual property rights and patents. This gathering signifies a crucial step forward in our collective pursuit of knowledge and innovation. I extend my sincere appreciation to Dr. Amrish Dubey, Dr. Shivanshu Srivastav for their dedication and vision in organizing this workshop. And I'm sure it promises to deepen our understanding of intellectual property rights and their implications in our fields. I can see with the participation of around 180 enthusiastic individuals, I am confident that this workshop will serve as a catalyst for fostering creativity, safeguarding the fruits of our intellectual endeavors. I am also delighted to acknowledge the generous support of the Council of Science and Technology, Uttar Pradesh, CST-UP, whose sponsorship has made this event possible. Their commitment to promoting scientific inquiry and technological innovation is commendable, and we are privileged to have them as partner in this endeavor. We are honored to host distinguished law experts from across the nations whose insight and expertise will undoubtedly enrich our discussions on patent laws and procedures. Through the many inlined, insightful lectures for today, we aim to equip ourselves with the knowledge and tools which are necessary to navigate the complex terrain of patent filing and protection. As we embark this journey of exploration and learning, let us seize this opportunity to not only expand our intellectual horizon, but also to forge meaningful connections and collaboration that will derive progress and innovation in our field. Therefore, I urge each one of you to actively engage in today's discussion, share your perspective, and seize the opportunity to learn for our esteemed speakers and fellow participants also. Together, let us harness the power of knowledge to propel ourselves to greater heights and achievements. Once again, I extend a warm welcome to all present here and wish you a fruitful and enriching experience at this workshop. Thank you.
Thank you, sir, for your valuable words. Moving on, I would like to invite Dr. Amrish Dubey, coordinator of the workshop, to inform us more about the detail of the workshop. Please give him a round of applause.
Thank you very much, Anshika, and very good morning to all of you. Honorable Director, sir, esteemed Chief Guest, respected Head of Electrical Electronics Engineering Department, honored deans, esteemed speakers, delegates, faculty members, participant, media person, and distinguished guests. I extend a warm welcome to each of you to the Intellectual Property Right workshop hosted by the Department of Electrical and Electronics Engineering at the Rajiv Gandhi Institute of Petroleum Technology. We are privileged to have with us today our esteemed chief guest, Dr. Pooja Yadav, Joint Director of CST-UP, and she is also leading IT Division, IPR Division in CST-UP, whose presence lent immense significance to our event. We also extend our heartfelt gratitude to our respected Director, sir, graciously agreeing to the patron of this workshop and for guiding us with unwavering support and encouragement. Dr. Yuri Dwivedi, sir, the head of Department of Electrical Electronics Engineering, has played a pivotal role in shaping this event and is serving as a chairman of the program. To all our esteemed delegates, speakers, faculty members, participants, and distinguished guests, a sincere and warm welcome. We are happy to share you that more than 200 delegates are participating from different parts of the state. Rather, it was 180, but today morning it has extended 20 more. Now, in different part of the state, the participants are from different prestigious institutes such as BHU Varanasi, IIT Lucknow, SBTU, RGIPT JIS, Lucknow University, and Allahabad University. Still, we are getting requests for more registrations. What makes it more beautiful or delightful is that very young students from engineering side have shown very high interest for this workshop. The background of participants is very diverse. The participants are undergraduate students, postgraduate students, research scholars, and faculties too. What excites me more is that there has been strong female participation for this particular workshop. Today's workshop promises to be an enlightened experience featuring insightful presentation from our distinguished speakers, each an expert in their respective domains of intellectual property rights. So one by one, I'm just telling the names. Dr. Vikas Bhati, he is Professor in Intellectual Property Laws at National Law University, Lucknow. will provide an overview of IPR, copyrights, trademarks, patent, and trade secrets, setting the stage of our discussion. Now, following this, Dr. Mani Singh, he's again a professor at NLU, and he's like a specialization of patent law and practice, will deliver into exercise of patent drafting, filing procedures, and patent laws. And furthermore, he will also emphasize on offering invaluable insight into crucial aspect of intellectual property protections. Further, Dr. Vijay Pal Singh, he is from IIM Lucknow, professor from IIM Lucknow, will enlighten us on IPR management side. And he will also emphasize on the strategic importance of effective management practice in maximizing the value of intellectual property assets. Then further, we'll be having Mr. Samrat Singh Kang from Khurana and Khurana Associates. Will share the expertise on IP enforcement and litigations, shedding light on the legal framework and process involved in safeguarding the intellectual property rights. And further, we are having one very senior manager of Hindustan Aeronautical Limited, Korba, Mr. Neeraj Saxena ji, Dr. Neeraj Saxena ji. He will discuss the benefits of having patent and its industrial importance, drawing from the extensive experience in the aerospace industry. Lastly, Dr. Rohit Rathore, who is a Deputy Controller at the Office of Controller General of Patent, Design and Trademark Delhi Center, will enlighten us on National Intellectual Property Rights Awareness Mission and also on the complete patent procedure. This workshop is going to impact very high in all our lives. Why? Because this workshop is going to raise awareness about protecting intellectual creations, encouraging proactive measurement to safeguard intellectual properties, understanding of legal frameworks, especially when the participants are going to gain clarity on legal frameworks governing intellectual property, ensuring effective integration of intellectual property laws and proper protection of creations. Enhanced innovation, it is going to create, a workshop is going to stimulate innovation by instilling confidence in protecting intellectual property, leading to increased investment in research and development, and fostering a culture of innovation. We are deeply grateful to our sponsors, Council of Science and Technology Uttar Pradesh and Khurana Law Firms Delhi, for their generous support, as well as the faculty members, staff of Electrical Electronics Department, for their immense contribution. We are really happy to see the student volunteer enthusiasm for this particular workshop. Really thank you all, especially student volunteers. Throughout the day, we encourage active participation and engagement for all attendees. Let us seize the opportunity to deepen our understanding of intellectual property rights, forge meaningful connections, and contribute to the advancement of knowledge in this vital field. Thank you very much. Thank you.
Thank you so much, sir. As a part of student community, I can surely say that we are very much excited to gain more knowledge and idea about patent and intellectual property rights. Thank you so much for giving us this amazing opportunity. Now, I would like to request our respected director, sir, Professor A.S.K. Sinha, to offer us his wisdom and viewpoints regarding the significance of intellectual property rights. Thank you.
Thank you. Respected Chief Guest, Dr. Pooja Yadav ji, Joint Director in UPCST, or number of resource person who will be joining us later as the seminar progresses. They are on the way. Our faculty members, students, delegates, many delegates will join also. They are on way. So I extend hearty welcome to all of you on behalf, my personal behalf, and on behalf of the institute. I'm not an expert of IPR, so it is difficult for me to tell more detail, but I know what is the importance of IPR. Nowadays, we are more focusing on innovation, enterprise, etc., etc. So IPR is very important to protect our intellectual right. And I am happy to see that large number of our students are there. That signifies that what is the IPR in their life. Soon they will be looking for a startup, innovation, and many of them are doing a project in this institute also, which may lead to many qualify for IPR. So the importance of IPR we very well know, and the seminar is very timely to enlighten us about the details of IPR. Though we take professional help of law agency for filing IPR, but nevertheless, some understanding is always welcome, and I hope that this seminar will provide us that understanding. Coming back to our institute, just to brief that it is an institution of national importance established by Government of India, and we focus on applied research, and our area of thrust area is the energy. So whatever we do in the as a part of project or as a part of research has potential of commercial exploitation, so IPR is very important for this institute. And we have been filing patents. Currently we are giving support to almost all ILPSUs. We are doing projects for them, and whatever outcome is there, we file joint patent, name the industry, OIL, ONGC, IOCL, HPCL, BPCL, CPCL, Numaligarh Refinery, and this NTPC. All we are doing projects with all of them, and so the outcome is always patented. So we are at present we do not have any IP cell. It works under Dean R&D take care of this patenting activity. Then we have to tell about our students. They are very much engaged in projects. They do long projects from second semester itself, and many of the outcomes are very are likely to be commercialized. So those are also part of patent. Then we have Section 8 company established in this institute. There is an incubation center, and it has been registered as Section 8 company, and soon we will have number of innovation incubation activity there. So again, patent activity will increase. So this year I wish that a full-fledged IPR cell is established in the institute, and I request UPCST, and she has also agreed that CPCST will help us in establishing IP cell in the institute this year itself. And this will be also this will also help in further improving our NIRF ranking as well. So with these words, I again welcome all the chief guests and all other participants to this workshop, and we wish that there will be many takeaways for you after this one-day workshop. Thank you very much.
Thank you so much, sir, for throwing some light on the importance of IPR.
Intellectual property rights encompass a set of legal rights granted to individuals or organizations for their creations and inventions. These rights provide creators with the exclusive control over the use and dissemination of their intellectual property, which includes inventions, literary and artistic works, trademarks, and trade secrets.
By granting creators the ability to protect their innovations, IPR serves as a crucial incentive for fostering innovation and creativity across various industries and disciplines. It encourages investment in research and development by ensuring that creators can reap the benefits of their ingenuity, thus driving the progress and advancement in the society.
To enlighten us more about the IPR, I extend warm welcome to our esteemed chief guest, Dr. Pooja Yadav, to please come on the podium.
A very good morning to all of you. First of all, I would like to thank Director Sir, Rajiv Gandhi Institute of Petroleum Technology, and Professor Ambrish Dubey, the coordinator of the workshop, also HOD Electrical and Electronics Department, for organizing this workshop on behalf of Department of Science and Technology, Government of Uttar Pradesh. I would like to tell you that currently Government of Uttar Pradesh as well as Government of India is focusing a lot on the development of innovation and registration of IPR within our country. And the rank of India in Global Innovation Index has increased tremendously since 2015. Earlier it was around 80 and now we are at 40th rank among 132 countries across the world. So in the past 10 years, we have made great progress in the field of innovation and intellectual property. It is not that earlier we were not doing innovation or we were not making techniques, but now we have focused on registering for patents and other intellectual property rights also, so that our innovations can be known globally, as well as we have exclusive rights over our innovations, such as no one else can use your innovation for commercial purpose. There are many intellectual property aspects such as patents, trademarks, designs, plant varieties, and geographical indications. And I think we have better experts who will throw light on various aspects of IPR. One thing I would like to tell, like, what is IPR? It is the intellectual property is a property of the mind. वो चीज़ें जो आप अपने माइंड से क्रिएट करते हैं, जैसे कि आपने कोई डिवाइस बनाया या फिर जब आप कोई बिजनेस स्टार्ट करते हैं या कोई प्रोडक्ट या ब्रांड लॉन्च करते हैं तो आपने उसका एक ट्रेडमार्क बनाया जो कि आपके ब्रांड का, उसकी क्वालिटी का पहचान बन जाता है वो सिंबल. जैसे कि आप एप्पल देखेंगे, कोका कोला देखेंगे, पेप्सी देखेंगे, मैकडोनल्ड्स, नाइक, एडिडास, तो ये सब जो ब्रांड्स हैं इनका जो ट्रेडमार्क है वो उनके क्वालिटी का सिंबल बन चुका है. अगर कोई उस ट्रेडमार्क को कॉपी करता है, कोई दूसरा उसे यूज़ करता है, तो उससे क्या होता है, उनका जो बिज़नेस होता है वो सफ़र करता है. लेकिन क्योंकि वो एक रजिस्टर्ड ट्रेडमार्क है तो वो उसके ऊपर लीगल एक्शन ले सकते हैं और किसी भी और फर्म को वो प्रोहिबिट कर सकते हैं अपने ट्रेडमार्क को यूज़ करने से. इसके अलावा हमारे और भी बहुत से हमारे डिज़ाइन राइट्स हैं, पेटेंट्स हैं, and then we have geographical indications. Geographical indications वो होते हैं जो किसी geographical, जैसे कोई प्रोडक्ट है और वो किसी स्पेसिफिक geographical रीजन के लिए फेमस है और उसका जो स्पेशल कैरेक्टरिस्टिक्स हैं वो उस geographical रीजन और उसके ओरिजिन की वजह से हैं. फॉर एग्जाम्पल यू हैव दशहरी मैंगोज फ्रॉम मलिहाबाद, चिकन कढ़ाई वर्क फ्रॉम लखनऊ, then you have Banarsi sarees and Banarsi pan, which is famous all over the world. So it is protected under the GI tag by Government of India. Like no one else can replicate that and say you are making a Banarsi sari in Europe. No, you can't do it. Banarsi sari belongs to Banaras. और इस तरह के जो GIs हैं वो ऑल ओवर इंडिया हैं. जैसे कुछ स्टूडेंट्स वेस्ट बंगाल के होंगे तो उन्हें पता होगा बंगाली रसगुल्ला, it is a GI from West Bengal. Then we have Kashmiri saffron and various other GIs from states such as Nagpur oranges, and we have Alfonso mangoes from Maharashtra. तो इसके अलावा लाइक वी हैव इंटेलेक्चुअल प्रॉपर्टी राइट्स के लिए यहाँ पे बहुत से स्पीकर्स ऑलरेडी हैं, सो आई वुड नॉट लाइक टू वेस्ट योर टाइम ऑन दैट. And I would like to tell you about some of the schemes of Council of Science and Technology, which is an autonomous body under Department of Science and Technology, Government of Uttar Pradesh, from which you can benefit, both the faculty members also and the students also. So our first scheme and the flagship scheme of Council of Science and Technology is grant for research projects. हमारी काउंसिल जो है वो 2 to 3 years के लिए रिसर्च प्रोजेक्ट्स ग्रांट करती है, जिसमें कि हम एक रिसर्च असिस्टेंट के लिए ग्रांट देते हैं एंड देयर इज़ कंटीजेंसी fund also. So these projects are around 10 to 15 lakh grant is given for a 2 to 3 year project. This is basically for promotion of research and development within the state of UP. और इसमें जिन fields में हम projects देते हैं वो है agriculture, pharmaceutical, medical, engineering and technology, information technology, and chemical sciences and physical sciences. So I think all the, except agriculture, all other fields are here at RGIPT. And we also have, some of the projects are running at RGIPT already. Then we have the CSTUP Summer Research Fellowship, which is for MSc students. So we don't have MSc here, but still I'm telling you about that so you can inform your friends and cousins. We have CSTUP Summer Research Fellowship for students studying in Uttar Pradesh in MSc. The students, we take around 60 to 70 students each year who are selected on merit basis, and we place them for research training at various institutes of national repute such as the IITs, the IISc, IISers, so that they can have a practical experience regarding research work, which is not readily available in various degree colleges in Uttar Pradesh. And we also give them a fellowship of rupees 25,000 per month for 2 months. The next scheme which is useful for students here is the CSTUP Engineering Student Project Grant Scheme. Under this scheme, we give a grant of 20,000 rupees for the final year project of BTech students. And the registrations are open in around September. So first you have to submit a basic proposal for the project, and then those proposals are sent for review to the field subject matter experts. So based on their recommendations, around 70 to 80 projects are selected each year for a grant from CSTUP. And we also have first prize, second prize, and third prize for these projects, which is rupees 1 lakh, rupees 75,000, and rupees 50,000. And besides that, we have 3 planetariums: the Indira Gandhi Planetarium, Lucknow, Aryabhatta Planetarium, Rampur, and Veer Bahadur Singh Planetarium, Gorakhpur. So this was a brief detail about the various schemes which could be useful under Department of Science and Technology, and thank you so much.
Thank you so much, ma'am. Generally, people have an idea that IPR is limited just to projects and startups. But today I got to know that its concept extends to things of daily use like the Shehri Aam and Banarsi saris and etc. So thank you for that. And thank you so much also for telling us about the various programs of CSTUP. I am sure the interested students will benefit a lot from this. Thank you so much.
Now, I would like to request our Honorable Director Sir to please come on the stage and present a shawl and memento to our chief guest as a token of respect.
Moving towards the end of the inaugural session, I'd like to invite on stage Dr. Shivanshu Srivastav, co-coordinator workshop, to deliver the vote of thanks. So.
Honorable Director, sir, respected chief guest, esteemed guests, distinguished speakers, faculty members, esteemed colleagues, dear participants, ladies and gentlemen, a warm and heartfelt good morning to each of you. On behalf of the Department of Electronics and Electrical Engineering, first and foremost, I extend my deepest gratitude to our Honorable Director, Professor A.S.K. Sinha sir, for graciously agreeing to be the patron of this workshop. Your unwavering support and guidance have been instrumental in shaping this event into a reality. I would like to express my heartfelt thanks to our esteemed chief guest, Dr. Pooja Yadav, Joint Director of Council of Science and Technology, Uttar Pradesh, for gracing this occasion with her presence. A special note of gratitude goes to Dr. U.D. Devedi sir, Head of the Department, Electrical and Electronics Engineering, for his invaluable leadership in organizing this workshop. I extend my heartfelt gratitude to the distinguished speakers representing various esteemed institutions. I extend my gratitude to the Council of Science and Technology, Uttar Pradesh, and Khurana Associates, Delhi, for their generous sponsorship, without which this workshop would not have been possible. I would like to thank the student volunteers, faculty and staff of the Department of Electrical and Electronics Engineering, and the RGIPT administration for their immense support throughout the planning and the execution of this workshop. Last but not least, I extend my heartfelt thanks to all the participants for their participation in the workshop. I express my sincere appreciation to everyone who has contributed to the success of this inaugural session. Thank you once again, and I wish you all a fruitful and enriching experience throughout the workshop. Thank you.
Thank you so much, sir. There is a slight change. We have our chief speakers of the session here. I'd like to welcome them all, and I'd like to call them on stage and present them a bouquet as a token of welcome. Please welcome Mr. Samrat Singh Kang and on stage, and I request our HOD sir to present him with a bouquet as a token of welcome.
Please give a round of applause. Now, I would like to invite Dr. Vijaypal Singh, Assistant Professor, IPR, Laws and Legal Management, IIM Lucknow. Please come on stage, and I would like Director Sir to give them the bouquet. Okay, he is on the way. I would like to proceed further. Now, I would like to welcome Mr. Neeraj Saxena, Senior Manager, HAL. Moving on, please welcome Dr. Vikas Bhati, Assistant Professor, Intellectual Property Law, RMNLU, Lucknow. I would like Director Sir to please give them the bouquet. Please give a round of applause. Now, I would like to welcome Dr. Manish Singh, Professor, Patent Law and Practices, RMNLU, Lucknow, to come on stage. I would like Director Sir to please present a bouquet. So, ending the inauguration session, I would like everyone to join us for a high tea outside the auditorium. Please enjoy yourself. We will be restarting soon at 11 a.m. So I would like to request you all to have enjoy your meal and come fast.
फर्स्ट ईयर पार्टिसिपेंट्स सब लोग अभी पहले सीट पर बैठो। अब देखो जितने कॉलेज के पार्टिसिपेंट्स हैं जिन्होंने रजिस्टर किया है सबको फूड कूपन्स मिले हैं, ठीक है। तो एक फूड कूपन तुम लोग फाड़ोगे, वहाँ बाहर एक बाउल लगा है वाटर के साथ, उसमें डालोगे तब तुम्हें प्लेट उठाने को मिलेगी। फिर तुम्हारा ब्रेकफास्ट का अरेंजमेंट है। और यहाँ पर जितने लोग हैं अगर कोई भी छोड़ कर गया, अभी री एंट्री होगी शाम को, उसका सर्टिफिकेट नहीं दिया जाएगा उसे, स्पेशली फॉर फर्स्ट ईयर एंड सेकेंड ईयर पार्टिसिपेंट्स। ठीक है, समझ में आ गया सबको? कोई डाउट? अगर कोई डाउट हो तो अभी पूछ लो। अब एक एक करके आएगा, एक एक करके एक एक लाइन से निकल के आओ बाहर। सबको वापस फिर यहीं पर आना है ब्रेकफास्ट के बाद, कोई यहाँ से भागेगा नहीं। और अगली बार आओगे तो ये 2 रोज में बैठना है लाइन से। छिटक के कोई बैठेगा तो अब समझ में, इधर इधर 2 रोज में ये जो हैं।
ये किसका है?
In the inaugural session, everyone must have gotten a brief idea about the workshop. So, now let's dive deep into the intricacies of intellectual property rights.
Intellectual property rights encompass various legal protections for creative and innovative endeavors. Copyrights safeguard original works of authorship, such as literary, artistic, and musical creations. Trademarks protect symbols, names, and slogans, identifying goods or services, ensuring brand recognition and consumer trust. Patents grant exclusive rights to inventors for new and useful inventions, encouraging innovation and investment in research and development. Trade secrets safeguard valuable information, formulas, or processes that provide a competitive advantage to businesses. Each facet of IPR plays a critical role in fostering innovation, protecting creativity, and promoting economic growth in diverse industries. To delve more in this particular field, I would like to introduce about Dr. Vikas Bhati, sir.
Dr. Bhati did his LLB from Faculty of Law, University of Lucknow, and his LLM from NLU Bhopal. He is also associated with university's IGNOU Center for postgraduate diploma course in intellectual property rights. His particular area of interest includes intellectual property laws, cyber laws, science and technology, and he is currently working as assistant professor at RML NLU Lucknow. So please give a round of applause. Dr. Bhati.
A very good morning. Morning to Director Sir, Professor Sinha, Dr. UD Dwivedi, Dr. Amrish Dubey ji, Dr. Pooja Yadav, Joint Director, CST UP, my co-speakers, and all the participants to today's program. The topic that had been given to me is about an overview of IPR, wherein I had been asked to talk about patents, copyrights, trademarks, and trade secrets. As my friend had been giving introduction about what IP is, what IPRs are. IP basically, or we say intellectual property, is the, it's not moving. So IP is about the creations of the mind. That is those works which had been created by human intellect. And they can be in various forms. For example, human intellect can reflect in the form of an invention. It can be a work of authorship in the form of a literary work, artistic work, musical work, etc., etc. It can be designs. It can be useful business information which can qualify to be a trade secret, etc., etc. These all, which are creations of mind, constitute to be the subject matter of intellectual property. IPRs, on the other hand, are the rights granted upon these subject matters. So if it's an invention, the corresponding IPR to that would be the patent right. If it is a sign, symbol indicating the source of a good or service, the corresponding IPR would be trademark. Likewise, if it's a literary work, it's a computer program, it's an artistic work, etc., etc., the corresponding intellectual property right would be a copyright. So IPR is rights over subject matter which comes under the umbrella term of intellectual property. At this juncture, we need to understand the distinguishing things about IP in contrast with the traditional property as we all are aware of. For example, a piece of land or an apple. Intellectual property is inherently different. I'm just touching upon this issue just to press upon you the importance of intellectual property. IP, the subject matters are intangibles. As compared to traditional property, where the subject matter is a tangible thing, something which can be perceived by your senses. You can see them, you can hold them, just like this water bottle. It's tangible property, it can be held in your hand. But intangibles are not so. They cannot be perceived in an equal measure as a tangible can be. But two key properties which would differentiate an intangible from a tangible is, an intangible is non-excludable as compared to a tangible. To give you an example, if I am an owner of, let's say, an orange, which is a tangible property, then I am in a position to perfectly exclude you from having the possession of it. That is, I can keep it under lock and key. And if in any case that orange has been, without my authorization, being acquired by someone, I had every right to retrieve it back from you. So it can be taken back. That is, at the exclusion of third person, another person. It's not the case with the intangibles. If I had a story, I may lock down the paper, but I am not locking down the story itself. And if you had read the story without my permission, there is no way I can get it back from you. I cannot take it back. It's not an orange. If you had read it, it would remain with you. I cannot further exclude you from having the possession of it. So an intangible is non-excludable. A tangible is excludable. Secondly, the consumption of an intangible is non-rivalrous as compared to a tangible subject matter. Let's take an orange again. If you had one orange and you had to give it to 4 people, each of them would not receive an entirety of that orange. They would be getting a 1/4 share of that fruit, but not the entirety of it. But if you had to share a story amongst 4 people, all of these 4 people would get the entirety of the story. These 4 people may choose to share that story with 4 million people. And those 4 million would also be getting the entirety of the story. This consumption is not of a rival character. It can be shared endlessly. And the value of that intangible for every person who has received it would remain to be an equal and in its entirety. So these two characteristics differentiates an intangible from a tangible. And therefore, the traditional set of laws which govern property are not perfect to provide for intangibles. Thus, the need of distinct laws: patent law, copyright law, trademark law, etc., etc. This was the what of IP and IPR. You must also understand the why of IPR. Why an IP right should be granted at the first place. You all are working in the field of technology, in the field of science. You all must be aware that R&D is a costly initiative. It's a costly enterprise. In making something, in inventing something, huge resources would be spent. And the only way you can recoup your sunk cost would be from the market. However, the person who has not invented it but is free to copy it would just make a copy without incurring any initial expenditure in the form of R&D, and thus would be able to sell the same product at a much lower price, because that sunk cost is not a factor for it. It's only the production cost. It's the cost of copying. It's not the cost of inventing. Being aware of this simple rationale, no one would be willing to invent at the first place. This is, in economics, an example of tragedy of commons. If something is declared to be a public good, and in case of, if it is a tangible that has been declared to be a public good, the consequent problem that would arise is the problem of overconsumption of that property. If you declare a piece of land to be a public good, open for grazing of your cattle, then every cattle in that region, locality would be on that field, irrespective of whether it's needed or not. So that resource would deplete at a faster pace. But one would say that you just had mentioned that intangibles consumption is non-rivalrous. So this problem of overconsumption would never arise. It can be consumed endlessly. And the value of the amounts consumed for everyone would remain the same. Because that can't happen in case of an intangible. But this problem of tragedy of commons would manifest in a different manner, in a different way. There would be a problem of underproduction. That is the amount of inventions. I'm not saying that would be zero. Inventions would happen. Expressions would come out. Trademarks would be developed. However, the amount would be at its minimum level. For the simple reason that a copier, a person who copied, had not to incur any R&D cost, had not to incur any sunk cost, while a true inventor has to. So without a guarantee of the law, right, we as a society would suffer from underproduction of knowledge. That is the why of intellectual property rights. Why rights must be granted over it. So this was the what and why. To give you a context of intellectual property, stats might be useful for us. Yeah? Okay. Now, assets, as in latter sessions, the valuation and other parts I hope would be covered. And you would realize that it's no longer, in the modern world, the industrial reality is not the brick and mortars. That is, the tangibles are no longer considered to be the most vital aspect of any industry. Most of the industries, particularly the industries which are technologically driven, be it pharmaceuticals, be it computing, be it other sectors. Their primary asset would be the intellectual property asset. And its value, I quoted certain examples for that. Google has recently purchased Motorola Mobility for $12.5 billion. So it's one single piece of technology. Microsoft took over 800 patents from AOL for more than $1 billion. In turn, Microsoft sold only 70% of those patents to Facebook for $550 million. Coca-Cola brand value in 2023, as per Statistica, was 106 billion US dollars. Just the value of this brand, the name. Music copyright, 30.1 billion US dollars. Coca-Cola's formula, KFC's recipes, Google's search algorithm are all priceless trade secrets. This is just to give you a context of how valuable that is and how much the industry has realized its central place in any and in variety of sectors. Moving on to the main topic, patents. How many of you have heard of patents? Okay, so there are good number of people who have heard of it. If I ask you what's the meaning of patent, as a simple word of English language, what does it mean? I'm not asking you the legal definition of it. As an English language word, anyone? If I ask you the meaning of latent, Yeah. Claiming any invention to be yours. Okay. Ownership of the invention. All right. And that's more or less moving into the legal realm. But as to the meaning of this simple word, open, let it mean something hidden. Patent means open, bringing it in open. That is, making it open to the public in this sense. As far as the legal definition is concerned, patent means a grant by the patent office for an invention under this act. It's an exhaustive definition. Patent cannot mean anything else in legal sense except what has been given under the Patents Act 1970, the definition of patents. It has two elements. One, it's a grant. That means that patent cannot arise automatically. It necessarily has to be given and obtained from the patent office. Secondly, it points out the subject matter for which a patent is given, that is an invention. It must be an invention. So if you think of things we do as works, every work cannot be an invention. A poem is not an invention, though it's a work, an intellectual work. So invention must mean something different. It's not something ordinary. Herein I am not suggesting to you that invention is something, a rare thing to occur. That's not the case. But inventions are not ordinary things. Right? And how they are not ordinary, we have to look into the definition of invention. Invention means a new product or process involving an inventive step and capable of industrial application. My friend was just giving a shorthand definition of patent in which he mentioned that it must be new and useful. However, in this definition, we can see that there are 4 things that must be present in what you claim to be an invention. First, it must be a subject matter, patentable subject matter, which can be either in the form of a product, either in the form of a process, or either it can be a product by a process. Right? So 3 things. But there is no definition as such of what are patentable products or processes. But instead, what the law tells us is what are not inventions. So there are 2 sections in the Act, Section 3 and Section 4, which enumerates those things which are not considered to be inventions. Though, in the technical sense of the term, and in the legal, as per the legal definition, they qualify to be an invention, but they are not patentable inventions. For example, Section 4 says that inventions relating to atomic energy are not patentable. Product or process, it can be a new product or process, plus non-obvious, plus useful. But however, as it relates to nuclear energy, Section 4 creates a bar. So for us, we are concerned about patentable inventions. And we can say that only inventions are patentable, but all inventions are not patentable. In the second part of this statement are those things which fall under Section 3 or 4. If it is under 3 and 4, it may be an invention, but it's not a patentable invention. So concern yourself with the issue of a patentable product or process. Furthermore, it must be new. New is a relative term. So you have to ask new in relation to what? Right? New in relation to the prior art. That is, the claimed product or process must not have been already a part of the public domain, must not have existed in the same form in a single prior art. For example, if it has been published about in a journal, or if it has been in use anywhere in the world, that product or process shall not be considered to be a new product or process. So what we need to look into is that on the date of filing of the patent application, this doesn't constitute a part of public domain. This was not there. So that's in relation to that prior to this date, it was not there. Second thing is that it must be non-obvious. Merely new would not suffice. It must be greater than that. Mere novelty is not enough. An invention must be non-obvious too. In simple terms, it means that it must be an inventive act. It must not be an act of an ordinary artisan. Okay. So what that is not obvious to person having ordinary skill in that art would be considered to be non-obvious. To give you an example, there's a very old case, Rockendorfer versus Faber, in which a patent was claimed upon a combination of a pencil with an eraser, wherein those two were combined using a metallic band. So an eraser was attached at the tip of the pencil. Overall, this combination is new. Pencil existed, eraser existed, but this combination didn't exist. So this combination is a new combination. This is useful too, but this is not inventive. Why? Because a person having ordinary skill in the art, that is a person who is dealing in pencils and erasers, if posed with the same challenge, then that's the obvious result he would reach upon. Right? So this is not an inventive act. This was a skill, but this was a skill of an artisan, an ordinary artisan, not the skill of an inventor. So to qualify as an invention, the product or process must rise to a level to be truly inventive and not merely an act of artistic skills or artisan's skill. This is the second thing that is required. Third is it must be useful. Now this is pretty simple to prove. Anything which can be manufactured in the industry, if it's a product or if it's a process, it can be used in the industry, that would be considered to be a useful product or process, and thus qualifying this third requirement. This was an overview of what must be there in a given subject matter in order to qualify to be patentable. Term of patent is 20 years. So for 20 years, a patentee would get a right to exclude others from doing certain acts. Remember, this is not a positive right. It's not a right to do. It's not a right to make. It's not a right to sell, etc., etc. But rather, it's a right to stop another from doing these 5 acts: making, selling, importing, offering for sale, or using, without the authorization of the right holder. So it's cast in negative language, it's a negative right, a power to exclude others for a term of 20 years. this was a brief overview of patents. Second is copyright. If we look into the general classification in which intellectual property rights can be placed, I'm not suggesting to you that these are watertight. However, that's a useful classification for us to have a beginner's understanding of IPRs. One is those properties which would fall into the category of being industrial property. So patents, inventions, they therefore would fall under that category. Industrial designs would fall under that category. The semiconductor integrated circuit layout design or topography, as you say, would fall under that category. Trade secrets, confidential information would go there. Second is expressions. Copyrightable subject matters fall under that category. Literary works, artistic works, musical works, cinefilms, sound recordings, dramatic works. These are all expressions of human intellect. Okay? Though they might be devoid of any merit, but they are still capable of being called to be an expression and therefore potentially protectable as intellectual property. The third category is about reputation and goodwill, wherein trademark and geographical indications would come in. I would deal with it later on. Coming back to copyright, as I was saying, these are about expressions of human mind. Herein, two words are of crucial importance. One, I'd say expression. So you may ask what kind of expression it must be. And second, the word I had used, human. So it's not expression of a machine. Okay? It's not expression of an animal. However artistic that might be. So there are three things basically essentials in order to obtain a copyright. One, the expression must be an original one. You must be writing your papers, you must be sending them for publication in various journals by you as students, by someone who is a researcher here, by the faculty members. So originality is a question that vexes us. So your work, your expression must be an original one. What does original means is, in simple terms, that it must emanate from the author. That is, it must not have been a copy of someone else's expression. However, the modern meaning of originality, as had been decided by the Supreme Court of India in Eastern Book Company versus D.B. Modak in 2013, is that originality has two components. One, it must be an independent creation. So this aspect, independent creation, is what I was stating earlier, that it must emanate from the author. It must not have been copied from somewhere else. It must have been an independent expression of the author and author alone. The second aspect is that there must be a modicum of creativity in it. So mere independent creation would not suffice. There must be a certain element of creativity, size of skill and judgment of the author. And there's a rationale for that. If by independent creation, let's say a compilation of factual information has been done, pure facts, okay? That compilation would not constitute to be a copyrightable subject matter because those facts were not independent creation of the author. They existed. They were not created by the author. All right? They were not an independent creation. However, one can say that this compilation constitutes to be a copyrightable subject matter because there had been an exercise of labor in doing so. Investment had gone in. However, that's not a valid justification because that would mean that therefore a copyright can be extended upon those subject matters which shall not be allowed to be a subject of property right of one individual. Facts are not copyrightable, ideas are not copyrightable, concepts are not copyrightable. They are free as air, free to be used by anyone. Okay? So compilation of facts would not grant a person a copyright over it. Third, what kind of rights? Second part is human authorship is essential. You must have heard of the monkey selfie case in which a monkey snatched a camera of a tourist and clicked a very cute selfie, which went viral in matter of hours. The question was who owns the copyright in that photograph, in that selfie. Whether it was monkey, whether it was the camera owner, the tourist, or whether it was PETA, the Organization for Animal Rights, which also fought this case, claiming the copyright over it. None can have a copyright over that selfie because of the absence of human authorship. If it exists, is the right over the tangible asset which belongs to whose camera it was. But none can have a copyright over that photograph, neither the monkey, nor the PETA, nor whose camera it is, because of the absence of human authorship. So this is a question which you would be dealing with when you are thinking of AI these days. What if the work has been created by artificial intelligence? Your essay had been written by it. Your article has been written by it. Right? Whether AI can claim a copyright over it. Simple answer to that would be, it's a computer generated work, capable of being protectable as copyright. However, if there is an absolute absence of human authorship, it's not copyrightable. Okay? So AI can join you as a joint author or a co-author. But AI alone cannot create a copyrightable subject matter because of the absence of that. Copyright is a bundle of rights. It may seem that it's talking about only one thing, right to make copies. It's not making of infringing copies, mind you. It's making of copies by the owner. So owner would not infringe his own rights. So right to reproduce, right to distribute, right to give it on rent, right to perform, to adopt, to translate, etc. So it's a bundle of rights that would vary depending upon the subject matter we are speaking of. And it's extended as a general rule, you can say that copyrights are granted for life plus 60 years, though in different cases that might vary, right? So say for example, if it's a government work, it would be for 50 years, it's a work for international organization likewise. The term is reduced. Registration is not required if some of you had observed the first title slide. At the bottom of it, I had used a C in a circle. Right? C, Dr. Vikas Bhati. So I am claiming a copyright over these expression slides. I had not sought any registration. So putting in a C in a circle is a sufficient notice to the public at large that you are claiming a copyright over this work. So registration is not mandatory. Compare it with the patents. You had to obtain it from the patent office. Copyright arises automatically as soon as you had made that expression. Lastly, fair use is a permissible act. Fair use under section 52 is a list of those acts which can be done by any third person without infringing the copyright. Just to give you an example, if you are using someone else's work for the purpose of research and not making copy of it, right? That is a permissible act. Used for the purpose of news reporting, a permissible act. Likewise, it's a list of those activities which can be undertaken by another person without the fear of being an infringer. Trade secrets, another interesting field of intellectual property rights. Yep. It seems that you seem to have mixed up two things. Novelty is not a requirement under the copyright law. Uniqueness is not required. I mean, these are terms which had different ramifications. In patent law, simply what is needed is that the invention must be new, non-obvious, and useful. In the example I had given, which you are quoting, that combination is new. Individually, the elements are not new. But combined, that combination didn't exist prior. There was no prior existence of that combination. So it's new, taken together, placed together. All right? It is useful too because of the practical utility of this combination. You need not have to search for eraser while you are using a pencil. It's handy. Right? It has practical utility. But this combination is non-obvious. It's an obvious one. So this is the question of patentability of that combination. The question you are asking about is compilation of, let's say, facts. Compilation of facts, one thing, they are not neither an independent creation, and if it is mundane, if it is too simplistic a compilation, then there is also absent a modicum of creativity. Say you are arranging the name of the students in your class in an alphabetical order, right? Let's say for the purpose of attendance. Now those names existed as a matter of fact. So there is no independent creation you had done. Those persons were the member of the class. So you had not independently created anything. Okay? The arrangement you had done of that factual information is a mundane one. You are arranging it in the most common way of doing so, that is alphabetically. Right? So there is no originality when we say that there was no independent creation of what constitutes to be that expression, and there is also not originality on the second count, that it also lacks in modicum of creativity. But if I say that you arranged the same facts in a creative manner, right? You are creating caricatures of your batchmates, okay, and using those caricatures a bit comic types. That is the creativity which is not factual. So that part is deserving to be copyrightable. However, that part which remains to be purely factual would not be. So modicum of creativity was seen in your expression in the form of caricatures. Okay? That being said, originality here means presence of these two things. Originality does not mean that something, this expression needs to be new. If you compare how high a threshold is, novelty is a higher threshold. Novelty means absolute novelty, not in existence on this date, right? Originality doesn't demand novelty. right? Originality neither demands non-obviousness. It can be an obvious expression. It can be an expression which is not entirely new. You see many works which are starkly similar but still are not copies of each other, right? So there is no requirement of novelty. Novelty is a very high standard as compared to originality. For copyrightability, something must not be new. That is, you are not inventing something. Instead, you are doing an original, making an original expression. So copyright doesn't require the expression to be new, neither it to be non-obvious, neither it to be useful. Okay. So let's say I write a computer program which doesn't works. It doesn't do anything. But I had used computer language. It can't be read by majority of the people. Okay? It has no function at all whatsoever. No utility. But that would still qualify to be a copyrightable expression. So those things, patentability requires very high standards. Because I'd say that invention is not an ordinary thing. If you contrast an invention with an expression, you would see the difference. That expression, though a work of intellect, is at a different pedestal as compared to an invention. All right. I hope I answered your query. Third, trade secrets. Trade secrets is a combination of two words, trade and secrets. One thing, it must have a value in trade. That is, economically speaking, in economic terms, that information must have value. Second, it must have a characteristic of, or you can say necessary attributes of being a secret information. It must not be commonly known. It must not be readily ascertainable by others. It must be one wherein a owner of proprietor of that information has taken reasonable measures to maintain the secrecy of that information. Only that information would qualify to be a trade secret. There is no specific legislation in India dealing with trade secrets. There are certain provisions in the penal law, for example, breach of trust, theft, etc., which can be relied upon. And largely in commercial arrangements or in employer-employee relationship, it's dealt with by the law of contracts. So you sign non-disclosure agreements, confidentiality agreements, non-solicitation agreements, etc., etc., in order to protect your worthwhile confidential information or trade secret. Herein, for your understanding, because you in coming times would be working at different places wherein you might be required to maintain the confidentiality of the information. Now, for you must think of information in this context. As of three types, an information can be trivial, that is an information without any consequence in terms of its economic value. Information of no significance, a trivial information. Or a confidential information not amounting to trade secret. And third is an information which is a specific trade secret. Okay? So these are levels of information. The practical difference would lie that once you are leaving your company, who was your previous employer, then your obligation to protect confidential information not amounting to trade secret would only be if there is a contract to that effect. That is, you had entered while in your employment with your employer into a contract which obligates you to protect the confidential information even after the termination of your employment. So confidential information, if you happens to be an employer, is protectable, or when it's not amounting to a trade secret, is protectable only by a restricting covenant in a contract. But if it is a trade secret, even in the absence of that negative covenant, restrictive covenant, it is protectable. So you would continue to remain under an obligation of protecting the trade secret, not divulging it, even after the termination of your employment. So one can say that every trade secret is a confidential information, but every confidential information is not a trade secret. So that is because of the reason that there is a practical difference between confidential information and trade secret. However, loosely these two are taken to be synonyms. The last topic that had been assigned to me, and the importance of trade secret is its term is perpetual. For as long as you are able to maintain the secrecy of that information, it remains to be your property. Coca-Cola formulas in existence as a trade secret for more than a century now. Lastly, trademarks. I'll just take 5 minutes if it's okay. I had time. Trademarks, we encounter them every day. What are they? What do they do? Several things were mentioned that this indicate they are guarantors of the quality, they are an advertising tool, etc., etc. But the most important function of trademark is to signify the source of the goods and services. Trademark doesn't define you the goods and service. In the introductory statement, I hope it was mistakenly, it was said that trademark tells what the good or service is. It's not that. Trademark tells you where it is coming from. Trademark doesn't answer the question what it is. Trademark answers the question where it originates from. Okay? Once you look upon that sign, that symbol, that mark, you are assured of that this is coming from the desirable source. Right? Trademark, and along with it GI, though that is beyond the scope of the topic assigned to me, are about reputation and goodwill. Trademark registrations throughout the world, as they are happening, the maximum number of registration applications in the last year were filed in India, as per Statista, the statistics website. So it's a very important kind of intellectual property right. Tomorrow you can be starting your startup. You may have to choose a trademark. What elements goes into in choosing that trademark is a branding strategy, which can be a subject matter of a different lecture altogether. However, one thing that you must be mindful of, that a trademark, in order to serve that function of being a source identifier, must be a distinctive mark. Distinctiveness, in simple terms, is the strength of the mark, which lies in its ability to distinguish the goods and services of one from those of another. Certain marks are completely devoid of that ability. So if I am selling apples, and I choose a trademark apple for it, it is generic a word. That is, it defines, being a generic term, the good itself. It's not distinctive. This word for a consumer would mean what the good is rather than where it is coming from. But Apple for laptop is an arbitrary use. BlackBerry is an arbitrary use. These are words of common English words which had been associated with a good or service which is completely different or had no relation whatsoever. Camel for cigarettes, right? So you may encounter several examples of that. They are highly distinctive. That is, the ability to distinguish an Apple's trademark bearing product would be much higher than a trademark laptop for laptops. Right? So the mark you choose must be a distinctive mark. There's one problem for the startups I would like to mention to you, and you are working in the field of technology too. There's a problem of genericide of the mark. Genericide of the mark is that when a piece of technology is developed, which is entirely unique and new, that has never been encountered before. So it's a kind of debut type kind of technology. The trademark you choose for that, there's a tendency of that mark becoming generic over a period of time. To give you an example, escalator was a trademark. Okay? Aspirin was a trademark. Xylophone was a trademark. But over a period of time, because the people do not have an ability to define the good or service, they start defining it by the trademark itself. Escalator was not generic a term. It was by the public usage that it became a generic term. When you are employing a trademark for your new technology wherein the people doesn't have a term to define it as to what that good or service is, then at the very outset, you must educate the people as to what the good or service is and what the trademark is. So if the escalator would have told the people that the good is moving staircases and escalator is a trademark, the genericide of this trademark might not have happened. There are two more things. Trademark registration is not essential. You can have a trademark unregistered too, that is also protectable under the law, but that is protected under the common law. So the only remedy you can seek for an unregistered trademark is the remedy of passing off. Passing off simply is that when someone else without authorization is passing off their goods and services by indicating to the consumers as belonging to others. This is the remedy in common law. Common law is law developed by the courts. But when you register it, you get two sets of remedies. That is this common law remedy as well as remedy for infringement of the trademark, which is a statutory remedy. That is remedy as per the Trademarks Act. The advantage is that if you happen to lose one case being a trademark proprietor, then at least you had a second option. Let's say if you are not able to prove infringement, then there's a chance that you can prove passing off, or vice versa. But if you had your trademark, if you had left it unregistered, then the only choice you would be having is seeking the remedy for passing off. And if you are not able to prove it, then your trademark is lost to you. Secondly, trademarks are in practical terms for perpetuity. Trademark registration is initially granted for 10 years, which can be renewed for 10 plus 10 plus 10 plus 10 plus years, for as long as it has not been abandoned by the trademark proprietor or it has not become a generic term. You can continue to enjoy the trademark. Those were the 4 topics that were assigned to me. Yes, any question? Yes, please. Yannick, you simply ask this question, whether this word or this sign is answering to the question what it is. If it does so, then that is a generic term. All right. Apple for apples is generic. Oranges for oranges is generic. All right. If it signifies what the good or service is, it's a generic term. Okay. If an image of an apple has been used as a logo and you are selling apples, then that's a generic usage. All right. So it's because of its lack of its ability to signify the source to the consumers. And secondly, for another reason, that the competitors also require that word or that mark in order to define their own goods and services to the people. That's also the reason that generic trademarks are not allowed. They can't be registered. There are other provisions as to whether if they had acquired secondary meaning, etc., etc. But how do you identify generic as? Ask the question, what does it mean to the consumer? If it means the good or service, it's a generic term, right? And it can't be a trademark. There are certain other forms of IPR, just to mention to them. Those are layout designs of semiconductor IC chips, wherein we are aspiring to become the second Taiwan. These layout designs are of very high importance for us, and in India there's been a very dismal registration of these. As far as I am aware, up till now only 2 registrations had happened. Though this is an act of 2000, so it's almost 24 years now. Industrial designs, it's another form of industrial IP. These are the designs which you encounter every day around you over the articles. Design does not have any separate existence from the article. So the purpose of design is to create a visual appeal. So when the products are competing, that is, the prices of 2 products are almost the same. One chooses a particular product over another depending upon what kind of visual appeal that article is, the design that has been employed upon that article is being able to create in the eyes of the consumer. Say the frame of your eyeglasses, the frame can be equally priced. Different frames would achieve the same function, but you would choose one over another depending upon how good it looks to you. So design gives a product a competitive advantage over the competitors' products. This is industrial design. Geographical indications, there had been a lot going on in this field of intellectual property. Common examples, Banarsi silk, sari, the Meerut Caesars, etc., etc. So those goods whose quality, reputation is attributable to a particular generation. This can be for the reason of the particular climatic conditions like Darjeeling tea, or this can be due to the human skill factor, the process of manufacturing maybe. For example, the Meerut scissors. They, because of their special quality, right, special reputation they enjoy, are protectable as geographical indication. Then there are plant varieties which are protectable separately under a different law. And there are emerging areas like traditional cultural expressions over which there is not yet any law. It's still being discussed. Traditional cultural expressions can be folk arts, mass, traditional arts, culture, part of cultures. Those things would fall into this broad umbrella term. That was the overview of IPR. I would take your questions now. If you have, I would like to invite those questions. Yes, please. Fair use. All right. fair use is not every use. ठीक है? Fair use is a use which is fair for certain reasons. Let's say an institution is making copies, verbatim copies, or say literal copies of the work for the benefit of disabled people. Right? You're turning a book into an audiobook. That is fair. Right? But taking a work and incorporating into your own. So it's not necessary that the entirety of the work had to be copied. If what had been taken is material part of the earlier work, qualitatively speaking, that would suffice to be called to be an infringing copy. So if there is a fair reason which is in the larger public interest, right, then that is permissible, otherwise not. So if I'm teaching in the classroom, I'm using a material, but that is for the purpose of imparting instructions to the pupils. That is fair use. But if I am copying an part of a song of someone else and incorporating into my work in order to commercially gain out of it, that is not fair use. If I am using someone else's work in order to make a criticism of that work, that is fair use. If I'm using it for the purpose of news reporting, that is fair use. But plagiarizing without permission, making a copy, unauthorized one, in order to commercially gain, that is unfair. Okay? It is.
So in case of patents, it has a tenure of 20 years. Why can't we have that lifetime subscription of the payment since we came up with the idea of it? Like in case if a patent is for like 15 years, if one doesn't want if one wish to renew it again and again and again, instead of that, why can't we have a lifetime subscription of that?
Patent is a very robust right, right? The likes of patent doesn't exist in any other intellectual property. 20 years are considered to be an adequate time in an industry to allow one to receive the benefits, due benefits, and efficiently exploit that patent. Okay? Because of its applicability in the industry. So 20-year terms is considered to be an adequate term for efficient exploitation of the patent. Extending it beyond would not serve much of the purpose, because the ability to continue to exclude others for long would impact upon the innovation process itself. All right? And it may also exclude the people from having cheaper version of the same object, the generic version of those things. 20 years is enough for him to recoup the investments, earn reasonable profits, right? An adequate time to efficiently exploit his patent. Okay? Then there is a consequent benefit that must accrue to the society. So we say that 20 years you exploit it, and after that it must form the part of the public domain. That is all. So 20 years is adequate. Copyright, though in today's times, people are arguing that life plus 60 years or even 60 years, 50 years is too extensive a term. Okay? But that's arguable, depending upon the nature of the work, depending upon the nature of the industry in which these works are generated. Okay?
But it's quite liable, right? Since he came up with the idea, he should have it for the lifetime, as in for a lifetime and perhaps after 60 years too.
No, but that's enough a reward. He has been rewarded. He has been given a power to exclude others for 20 years. 20 years is enough for him to gain commercially out of it. His recognition as an inventor would continue throughout his life, that he has invented this particular thing. Right? We remember who invented penicillin. We do not remember that person for the sake of the patent granted to him. So his name and fame continues. His recognition as the inventor continues. But his ability to economically exploit 20 years is enough for that. Patent doesn't necessarily adds to the fame of a person.
Okay, thank you.
Okay. Okay, we can have just one last question. I had given on the last slide the ID. If any queries remain, they can direct those queries to this ID. Yes.
Sir, like the Volvo invented 3-pin seat belt in 1960s. Earlier they have patent of that, but then they left open for other companies to join that. So it's for human welfare. So is it okay to patent it and then left it open? Or
Yeah, that depends upon the objectives of the enterprise. Okay. Sometimes, depending upon what objective the enterprise is seeking, if you compare a public enterprise with a private enterprise, say for example, developments in the field of agriculture, right? So as ma'am should also agree with me that Indian Council of Agriculture Research, their mandate is to provide the results of the research to the farmers for free. Okay? This is the objective of that enterprise. A private enterprise must have making profit as its primary objective. So what it does with the patent is open for the patentee. But the essential condition is that patent must be worked. One cannot sit idle upon his patents. He has to annually file a working statement as to what extent that patent has been worked. So those are requirements he had to comply with in this period of 20 years. What he cannot do is sitting idle over it and using it as a blocking patents so that others are not able to use it. He has to use it. For what purposes, whether he gives it for free or whether he gives it for profit making, depends upon what objective that particular enterprise has. Am I clear on this? Yes. Okay, thank you very much.
Thank you, sir. Thank you, sir, for your enlightening words. As we got to know about complete overview starting from tangibles and intangibles, of IPR to great details about patent, stating an interesting example of mensurable combination. Also, we all got the knowledge of copyright and the importance of human authorship through an interesting example of mugging selfie. Now, I would like to request Dr. Bala sir, our Dean of Research and Development, to please come on stage and present shawl and memento to sir. Thank you very much, ma'am. As ma'am is leaving now, so I would like to request our HOD sir to please come on stage. And present memento to ma'am.
Meanwhile, thank you so much, ma'am, for collaborating with us, and we look forward for further collaboration also. Thank you.
Thank you, sir.
We would like to request Dr. Bhati to come on stage so that we'd like to present a shawl and memento as a token of respect. So please. Moving on, we have our other chief speaker, Professor Vijay Pal Singh here. I'll request our HOD sir and the chief speaker to please come on stage so that we can welcome you with a bouquet as a token of welcome. Please, sir.
Thank you, sir. That was a wonderful session. So moving on forward, drafting a patent involves meticulous documentation of invention details, including description, claims, and illustration, adhering to strict patent office guidelines. After disclosing the invention to patent attorney, a comprehensive search ensures its novelty. Filing begins by selecting appropriate jurisdiction and submitting the application. Examination assesses compliances, and upon approval, the patent is granted. Patent laws govern patentability, disclosure, exclusive patent rights, and enforcement. Patent grants holders exclusive rights to utilize, license, or assign their inventions, crucial for safeguarding intellectual property and commercializing innovations. To delve more in this particular field, we have Dr. Manish Singh.
Dr. Mani Singh is a professor of law at Dr. Ram Manohar Loya National Law University. He previously served as an assistant professor at the University of Lucknow and Bareilly College. Professor Singh is a registered patent agent and empaneled patent facilitator with the Indian government. His academic focus includes intellectual property laws and business laws, particularly in patent law, corporate law, etc. He has authored numerous research papers, supervised research projects, delivered lectures, and actively participates in organizing seminars, legal literacy camps, and moot court competitions. Now, please give a round of applause for Sir to come on stage and give.
A very good afternoon to all. In absence, I'd like to thank Director Professor Sinha, Dr. Pooja Yadav, Joint Director CST, the Head of Department of this institute, and the organizing committee of this workshop. So the topic that I'll be dealing with is drafting of patent specification and the filing procedure. Dr. Bhati has very concisely make you aware about the intellectual property right in the form of patents. He told you about the finer nuances, what a grant of patent is, what is patentable. I'll just brush up. And one more important thing that might clear your confusion as to the patent law or the patents. Patent and all IPRs are basically a branch of business law. The purpose of every IPR is to provide the economic benefit of the intellectual endeavor of the author, creator, and whoever have designed, invented a trademark. So the purpose is that he should get the benefit of his intellectual endeavor. The patent is a right that is to be granted. By whom? By the government. And why? Because you are asking the government for that protection, that of your intellectual intellect in creating something new, in inventing something. You want that the economic benefit should not be taken by any other infringer. So you approach the government, the patent office, that he should be granted a patent. So patent is an exclusive monopoly right granted to the inventor or whoever holds that particular invention, that for the period of 20 years, he'll be allowed to reap the benefit of that intellectual invention. But then, anybody who infringes or works on that particular invention, makes it, sells it, uses it, he'll be liable for infringement and to make good your economic loss. But then, what you are giving in return? You are giving in return the complete disclosure, so that when the period of 20 years lapses, then the information falls in public domain. So your period of monopoly under patent law is restricted only to 20 years. You are not allowed to renew it. That is evergreening. Because, as Dr. Bhari told you, 20 years is supposed to be enough time within which you can make economic benefit out of your intellectual intellect. And because the government, on behalf of the society, is providing you a limited monopoly for 20 years, therefore, in return to the society, you must disclose your information to the fullest. In the way that after the lapse of 20 years, when the information comes in public domain, any person skilled in that particular art must be able to understand it and use that invention, your whatever you have done, just by going through your disclosure. He should not have to use any inventive ingenuity in that particular thing. Just by going through your invention, whatever you disclosed, he can work out. So this is basically the law of patent. So patent is, it is to be granted. Just by inventing, you cannot get a monopoly right. So the students of this university and all persons who are acting in the fields of science and tech, they are doing researches on a day-to-day basis. They come across with certain problems and they must have found novel solutions to that particular problems. And they have written down those novel solutions and must have published a paper. So I've seen that many of the students, scholars, they have published multiple papers on each and every aspect of their research. Without thinking, without taking into notice that maybe any such solutions that they have found to the problem, it may be so novel, so non-obvious, that it may qualify for the grant of patent. Don't think patent as something which is granted over some complex solutions. No. A very simple solution may also grant you a patent. Even, the clip of a pen to fix the pen on the pocket without falling it down may qualify for a patent, provided it is a novel solution, it is not obvious. Obvious is something which, as he told you, it is a solution which is found by an artisan. No, it should be a solution from the inventor. So I urge you that next time when you go forward with your experimentation in the lab, think over it, think and check it with the prior art. Your next solution may qualify for a grant of patent. Just don't publish it, because we grant patent for solutions, for some invention which is novel and not in public domain, and something which is not obvious to whom? To the person ordinarily skilled in the art. It is not the layman we are talking about. If you are a scientist in the field of electronics, we are talking about a person skilled in the art of electronics. Yes, thank you. Now, one thing is, there may be multiple people working on a particular problem in different locations. They may come up with the solution simultaneously, the same solution. Then who will get the patent? First to file. So we follow the system. Internationally, it is now being followed. First to file. It is not the first to invent who will get the grant of patent. It is the first to file. You have to be the first mover. So as soon as you have come up with a novel solution, an inventive step, an invention qualified to be patentable, you must approach the patent office. Because the protection for your invention under patent starts from the date of filing. And once something has been filed and published, falls in public domain, you will lose. What is novelty? You will lose the novelty. Novelty is something which is not there in the prior art. It's not existing previously. That knowledge is your creation. But if it is in public domain, public know about it, they use it, then you lose the novelty and you lose any grant of patent to your invention. So it is important that as soon as you conceive some invention, you start making progress to approach the patent office. So this is an overview that we have a patent office headquarters at Kolkata, then the branch offices at Mumbai, Chennai and Delhi. And this is the patent office, how it functions under the Controller General of Patents. There are joint controllers, assistant controllers, deputy controllers, and below that, examiners who examine your patent application. So the process is, once you have conceived an invention, you draft a whole patent application, you file it with the controller office, controller will send it to the examiner. Examiners are assigned for each and every specific field of science and tech. They examine it, and then they forward a report to the controller, and based on that, your grant of patent may be allowed or may be denied. Right. So what is invention? Invention is, it may be a fundamental research. It may be improvement of existing art. You must have made an improvement. Solving unsolved problems of art or unaddressed issues. You have found a novel solution for that, or you have taken a different approach. So invention is something which is a technical advancement, and also if it is an economic advancement, in the sense that your invention has made the whole process more economical, it still qualifies for the grant of patent. So before drafting, which is an essential element, you have to submit a complex draft to the patent office. Before drafting, you must understand what is the invention. What is your invention? So your invention is the novel solution which is not in the prior art. So say for example, you have experimented over a motor fitted in a fan. And that motor reduces the friction, that motor uses less electricity, less power, and some more benefits. So your invention is not over the fan. Your invention is, you understand, what is the prior art? There was a fan with this motor. I've invented this addendum in the motor, and that qualifies to be patentable because either it is technical advancement or make the things more economical. That is your invention for which you will get the patent, not the whole fan and the manner in which functions. Is invention patentable? So, Section 3 and Section 4 of the Patent Act, they provide certain exceptions. They may qualify to be inventions, but they are not patentable. So based on public policy, depending upon certain things that they work in a fashion which there's no inventiveness, so they are not patentable. Then is it novel? Is it inventive? It is in prior art or not? Then you must see, have you disclosed it to someone in written, oral, or whatever form? Because if you have disclosed it to someone, it is in public domain, though there are certain provisions which may still be used to retract your invention even after your disclosure within a limited period of time. Or whether it is published somewhere in printed form, or whether it is in prior public use. If that is there, you lose the novelty. So you have to establish yourself first that whatever you are treating as your invention, it is to have a novelty, it's new. It has an inventive step, meaning thereby that it is not obvious to the person skilled in the art. It is not, should not be a work of artisan, it should be a work of an inventor. Then you must see that whether your invention can be used in the industry. Is it industrially applicable? Process can be used in industry or not? After satisfying yourself of these components, the last component of granting of patent is true and complete disclosure. So these are certain, do's and don'ts for before you start drafting. You must conduct a search. It's a very different topic itself. So you conduct a prior art search. Basically, there are different types of searches for different purposes. But one is searching for the prior art. So suppose, and this prior art search is again a technical search, and it depends upon how in what manner uses the catchwords in the search option. So suppose you are working on some crystalline discs. There are so many types of crystalline discs. So you want to know whether your invention is there in prior art or not. So you start searching. Say for example on Google Patents. You will type in some catchwords to get your results. So as soon as you type crystalline disc, you will find some lakhs of patents bombarded upon you.
So you have to refine your search. Because suppose you treat your invention or your work in the field of crystalline disk, but it is actually active matrix crystalline disk. As soon as you put this catchway word in the search engine, the queries, they will get reduced. So you maybe have some hundreds. Go through it and see whether what aspect you are treating as your invention, whether it is in prior art or not. You establish yourself first. Then, what is the problem that was there in the prior art that for there is no solution and you have provided a novel solution? Establish yourself. What is the novelty of an invention? Then it is obvious or not, whether publication is there or not. And then you decide to approach the patent office for the grant of patent. Now, when you start writing patent specification, you must understand how, by whom, and where that is to be used. So that is to be used by the patent office initially for the grant of patent. The examiner will examine, will go through a substantive of your application. So first is whether it fulfills the purpose or what are the mandate of the act itself. And secondly, whether it qualifies to be an invention which is patentable. Then licensor assignee. Suppose you as a student have come across with an invention, it has industrial applicability, but you don't have capital to manufacture it at industrial level or to market it. You assign it to someone. Okay? You'll get the royalty out of it, you assign it to someone. Or you license it to someone. So that specification will also be read by the assignee before paying you it. Will determine whether what is the status of your invention, how strong it is. In case of infringement proceedings, court will also interpret your specification. Skilled persons, because as soon as you file the invention, there is a procedure for seeking objections from the public. So any person in your field working in that industry will definitely look into your disclosure, whatever you have disclosed, and will see whether you are asking for a right patent or not, whether it is patentable or not. Competitors will also go through it. Commercial players will go through it. General public will go through it. So your invention must fulfill the need of all. So patent application is a techno-legal document. It's not simply technical document. It's a techno-legal document. So when you approach the patent office, you'll file the application along with the specification. Specification means you have to divulge the intricacies of your invention to the patent office under certain heads, and those heads have different use for different persons. Now those specifications can be of two types: provisional and complete. Provisional means that in complete specification, when you divulge information, then you are doing whole exercise for the purpose of seeking some protection, and those are called claims. So at the last, when you have completely described your invention in the specification, it must end with at least one claim, and that is the legal protection, that is the scope of your invention, for which you are granting will be granted the patent for what. Then again, there are different types of applications also. Domestic application, you want patent in India also, you can just file domestic application. Because grant of one again misnomer, there is no such thing as international patent. No. Patent is a territorial right granted by different jurisdictions. So you want patent in India, you will file in India. You want in America, you want file there, will be granted there. Things which may be a patentable here may not be patentable in different jurisdictions. So it is totally territorial. So your invention, suppose it works out to be fine with using in India, Southeast Asian countries. You want to get patent in all those countries. So what is the method? The method is that you file in each and every jurisdiction simultaneously, because as soon as you submit an application in one jurisdiction, it is published, it is in public domain. You will lose novelty in different other jurisdictions. You will not get patent. There is a procedure prescribed, and it provides you with a mechanism to file your application internationally. And that international filing will only give you a similar date of priority. Date of priority means the date from which you will get the protection of your invention. So it may be under Paris Convention. So there is a convention between certain countries, and they agree that if you will file an application designated as international application, we will grant in all member states the same date of priority. And the other is Patent Cooperation Treaty. Again, it is a treaty of certain members of the community, the world, and they have agreed so. So its head office is in Geneva with different offices in different jurisdictions. So you file one application under PCT, a different procedure is there, designating certain countries. And then within a period of 12 months, you have to file domestic applications in those jurisdictions. So you want your patent in India, in USA, in France, in Germany. You file an application under PCT, stating it to be under PCT with designating countries, India, France, Germany, USA. Then you have 12 months to file individual application in those jurisdictions. So now you send someone to America or you contact with the attorney, he'll file it there, everybody, within 12 months. So it may be that after 3 months you have filed in USA, after 6 months in Germany, after 7-8 months in France, but your date of priority shall be counted from the date of first filing under PCT or novelty. Okay? So you have determined what is the scope. Because just getting patent is not important, you have to also assess what economic benefit it has and where you can get the economic benefit. Then there are two more type of applications, divisional application, patent of addition. We'll treat it later on. Now, so one is provisional application, other is complete specification. The difference is, suppose you have conceptualized some technical solution to a problem, but you are still not sure about the scope of it. But it is novel. It is not obvious. And you want, because who will get the patent? First to file. You want to be the first mover, but you are not sure as to what claims you have to ask for. Again, you submit, in case of urgency, a provisional specification. But in provisional specification, you have to divulge all the information that you have at the time, but it is not required to submit any claim. So provisional specification is the brief understanding of your invention, the problem there in the prior art, the solution that you have prescribed. But how actually it will work out is not sure. You don't claim anything now. And then within period of 12 months, so you will get the date of priority from the filing of provisional specification. Within 12 months, you can again file a complete specification along with all the claims. So whatever you claim, dependent upon the disclosure in the provisional specification, the date of priority of first filing, that is filing of patent specification, which is provisional. You can still introduce new things not divulged in the provisional specification. For that, date of priority may change because you have disclosed it later on, and which is not based on expressly on what you have divulged earlier in the provisional specification. So suppose you have worked on some research, some new thing has been invented by you, but you have to submit your thesis. You are in a hurry. You submit it. But before submitting, you just file a provisional specification. Then you have 12 months. After submission, you can still have 12 months to work on that particular thing, come out with the complete specification, claim. Date of priority shall be from the first filing of provisional specification. It's a very important thing. So, accidental disclosures, yes. It's very important. Suppose you are working as a team in some group on some invention, you come across with it, before getting application filed in the patent office, that is divulged accidentally to the public. What remedy you have? The remedy you have is that if it is without your permission, within 12 months you just file it. There are certain disclosures. Suppose you have invented a device and you have exhibited the device in an exhibition which has been organized by the government, to which the Act applies. So this is a regular requirement. You disclosed it there, you exhibited it, you let other people work for it for experimental purposes. Then again you have 12 months within which you can file. So that will not be treated as disclosure to the public. That will not lose your novelty. But the thing is, be a first mover, you file provisional specification, and then within 12 months you file a complete specification. So, what is the provisional specification? It's a document describing the invention and need not contain claims. Disclose as much as possible, and that decides the date of application. So when you start, you write, it's a provisional specification, and the following specification describes the invention. It is only describing the invention. Then, a complete specification, as I told you, it is a techno-legal document describing and specifically claiming the invention. So you have this latitude only when you are filing a domestic application. In case of PCT, you have to file at the first instance complete specification. There is no latitude is given in that. So when you write a complete specification, the following specification particularly describes and ascertains the nature of the invention and the manner in which it is to be performed. So this is where you specify, you disclose clearly each and everything with the help of figures, diagrams, whatever is needed, and then you claim. So, coming back to specification, a specification has two parts. One is the detailed description under certain heads, and the second part is claims. So every specification, every disclosure must end with at least one claim. And what you are claiming? You are claiming your invention. Don't claim something which is not yours. Okay? And don't leave something which is yours. So while drafting the claims, you have to take a very, serious note of it, that whatever you are claiming, whatever you're writing, whatever language, it must cover all the inventive aspects of invention and must not leave anything which you have invented. So you should be very sure about what should be the length, the breadth, and the depth of your invention, your claims. And one more thing. It is said the name of the game is claim, meaning that whatever you have disclosed as your invention, you must claim. If you will not claim it, it will stand disclaimed and fall in public domain. So once this specification is filed with the patent office, it cannot be amended substantially. For clerical wrong errors, you may be allowed to amend. But you cannot amend substantially. You cannot say, oh, sorry, sir, I have submitted it, but I forgot to claim this. No, it is not in public domain. Once published, it is in public domain. You will lose your claim over it. Are you clear? So what claim defines? It's the boundary of your monopoly. Whatever you have claimed is something which you get. And description includes drawings. You have to substantiate your work with the help of drawings also. Drawings are within the purview of specification or disclosure. The patent examiner may ask you that I am not able to understand your invention, kindly make a model of it. You prepare a model, give to the patent office, that will not suffice to be within the boundary of specification. Now, what is the importance of it? So you have disclosed your invention described with the help of figures and diagrams, and you have claimed everything that you stated in the description, but you fail to claim something which is stated in the drawings, not mentioned in the written description, and not even claimed. So what you will say? That okay, fine, I have not written it, it's in the drawings, but drawings will be in the purview of specification, you will lose your claim over it. So whatever and everything, this document will be very consistent. Whatever you have claimed must be in the specification, whatever specification is there, it must be in the figures, figures must correlate with the specification, and whatever you have divulged must be in the claim. Write and rewrite, look and relook. There should not be any ambiguity, there should not be any inconsistency in the whole document. So for the purposes of writing specification claims, you can be your own lexicographer. You can coin new phrases, new words. But that must be used consistently. So say for example, you invented certain device where embodiment A is attached with embodiment B with the help of a screw. So you say that, okay, this is my invention where there's a device in which there are two embodiments, A and B, they are attached and they are working in some certain manner and they are attached with the help of a screw. Now, anybody can use any other method, nail, fixture, anything, can bypass your invention without infringing it. Because what you have claimed that in your invention, the two embodiments are fixed with the help of screw. Coin a new phrase, make it as broad as possible. So what comes to your mind? What comes to your mind? How you enhance the scope of this? Okay, so you come, no, I can attach with the help of screw, the rivet, there are three comes to your mind. So you say, B are attached with the help of a screw or nail, or I can use another fourth. Again, I bypass. Yes? What a method? No. It's ambiguous. What method? So embodiment, I try to make it more enhanced. Embodiment A and B are fixed by means or any fastening means. So though it enhances your scope, but you have to see that any fastening means if you have used a glue, which is a fastening mean, and your device heats up on function, and when it heats up, the glue separates. Invention is not fit for patentability. You lose the claim. Right? So be very specific about it. So this is the typical part of a specification in India as we file it. And every part has a different, purpose. Title of invention, then the field of invention, then the background of invention, the object of invention, the statement of invention or the summary of it, then brief description of the accompanying drawings, detailed descriptions, claims and abstract. So just briefly go through it. So title is the concise statement providing the crux of the invention. Just by going to the title, one can understand what your invention is about. A process for, a device for, right? So be very specific and in very concise, in 15 words, you have to write the title. Care should be taken to incorporate all major aspects, whatever you have claimed. So a device to perform certain function, a process to prepare something, including this. Whatever you have claimed, title should be incorporate everything. It may be a product, it may be a process, it may be an apparatus, it may be product or process, whatever it is. But again, you have invented a brush for cleaning. So what you claim? It's a cleaning article. It's not a brush. Make it as broad as possible. Pen versus writing instrument. So you have devised a pen, don't call it a pen, it's a writing instrument. Nail versus fastening means, okay? So be as broad as possible, but as broad as possible means without infringing others' patent and not leaving anything which is yours. Field of invention. Now, field of invention is for the purpose that if your title is not explanatory of your invention, one can look just to one more thing, that is the field. It carries more details than the title. It provides utility, and sometimes it can be used, if there is no abstract, it can be used as a search tool also. Okay? So it may have something more than it defines. The present invention relates to the field of whatever field. It may be stoichiometry, it may be whatever technical name that you can relate to that. What is the benefit of it? You can write in few lines. Background. So before you start describing your invention, you have to tell what is the background of. What was the prior art? What was the problem in the prior art? For what problem there is no solution? That was the problem part, prior art. Okay? So in that you describe the prior art, its drawback. That this device of the prior art fails to do this, do this, do this. This process has these failures, drawbacks. Then we come to the next, objects. So these are the drawbacks of the prior art, I have explained already. Now, this invention has these objects. So the primary object of the invention is this. There may be more than one. A secondary object is also this. A further object is also this. Each and every object must be there. Now, while writing the objects of invention, again, you should be very sure because there is a danger. And the danger is that statements of your objects, they may tend to limit the invention. Say, for example, object of the invention is to provide improved safety when lower cost is also an object. If you don't write that primary object is improved safety and the further object is the lower cost of the whole process or the equipment, then your claim is sufficient up to the improved safety and not the lower cost. Should not limit your invention by using this phrase, what is the object? And when you start writing the object, then you revisit after writing specification, or you write whatever is your novelty, whatever new you have introduced, whatever new you have provided over the prior art, these are all your objects. Claim it then and there. Summary. So basic summary is that I don't want to go into detail of your invention, which describes each and everything in so complex form. I just want to know what you have done. What is the process? So summary is, you write your thesis, you write a summary of it. Thesis is into 250 pages, thesis is in, say, 50 pages or 25 pages. What do you do in summary? You summarize the whole thing. Summary means everything. What is the problem? What was the solution that you have devised? How it functions? Everything. The purpose is that if anybody don't want to go through the whole details, just by going, and title is not, definitive of what you have done. Objects are still not clear. I want to go through what you have actually done. Just go to the summary. You summarize. There's no word limit prescribed for it, but it should be as concise as possible to make understand the person what you have done. Detailed description. What is the requirement of it? Because you will grant the patent for your invention. Invention should have certain elements. You already learned that. Novelty or newness, inventive step or non-obviousness. It is not something which is very obvious to an artisan. No. Then the industry patentable under Indian law of patents. That is, it is not hit by section 3 and 4. Now, when writing specification, the specification in such a manner that each of these elements must be depicted there. How it is novel, how it is inventive, how it is industrially applicable, and it is not hit by section 3 and 4. It is a subject matter which is patentable and not patentable. So you write the specification in such a manner that all these elements must find place in your specification. And this description sets out the best mode of performing the invention. Now this is one more thing. That Indian law requires that when writing the specification, you must also tell what is the best mode known to you. Because you are claiming not that device, not that process. What you are claiming, in fact, the first question to be asked, in fact, from you. What you are claiming. In copyright, you claim original expression. What you claim in patent? Any answer? What you want protection for? When you are using a nail or a screw to fix two embodiments, why you are claiming a fastening means? You are claiming not the device, you are claiming the idea. So what are patentable? It's not device which is patentable, it is the idea which is patentable. Are you clear? So you must tell what is the best mode. So when you write your claims, you claim that in my invention I claim a device A attached with device B with the help of fastening means, then please tell what is the best method known to you. So one of the embodiment or one of the method in which A and B can be joined together is by the use of screw. Okay? Other means which fit in the spirit of the invention can also be used. But you must tell what is the best method known to you. Yes. It describes the invention in greater detail with example, illustrations, tables, graphs, diagram, etc. And description must be sufficient to enable a person skilled in the art to put the invention into practice. And this is, when you submit an application to the patent office, again back to you with some objections, something may be asked from you, then you send the objections, you rectify the objections, you provide your solution and anything. This process is known as patent prosecution. In the last, when everything is satisfied, you will get the patent. So there may be a situation that you submit the application, but the examiner is not, amused by what you have described. Maybe the drawings are not complete, maybe you have not described it in detail, maybe your claims are not very clear, ambiguous, you'll send it back to you to rectify these mistakes. So, what happened actually? Every inventor knows that after 20 years, his invention will be in the prior art. It will become prior art, open to public for use. He wants to divulge as less as possible. Isn't it? So if something is my invention, so I would like to have the grant of patent with the least divergence of information. But patent office wants the reverse. They want everything should be described in detail so that a person skilled in the art can work through your invention just by going through your whatever disclosure you have made. If he has to use intellectual, inventive ingenuity, it is not a complete disclosure. So there is a hypothetical person created, a person skilled in the art. Now that person, a hypothetical person, is a person who has every knowledge, general knowledge, have means to go through experimentations, but does not have inventive ingenuity. He must be able to work your invention. It's not a common artisan also, and not the inventor also. Claims. Now, claims, they define the boundary of your invention. What you actually want protection for. What is your invention? So whatever you have described as your invention, having novelty, inventive step, you must claim. There may be a possibility that one invention may have different aspects to be claimed protection for. So instead of writing one claim, you may have certain claim sets. Say for example, you have devised an apparatus for preparation of tea, as I know the best, and the method of preparation of tea. Okay? So the apparatus is a bowl shaped with a handle. That is my invention. And the process is that you put the utensil or the apparatus, in technical word I say, on the flame, you pour the water and you add sugar and some tea and milk and put it to boil. This is my process. So there are two things I am claiming for. One is the apparatus, and the other is the process by which, by using the apparatus, tea is prepared. That is the best method known to me. Okay? So what should I claim? First is, I claim the apparatus. This is the one set of claim. And the other is the process. Now, the best method known to me is, it's a bowl with a handle, the utensil, the apparatus. So it may take any other shape. It may be with a flat bottom. It's not a bowl. So my invention is bypassed without infringing because I have claimed a bowl. Right? What I have claimed an apparatus and method for preparation of tea. You can make so many things on that. So try to be as broad as possible while writing the first claim. And the actual practice is that you write first claim set as to your apparatus, other claim set as to your process. Then try to remove the limitations of your invention or your claim by using more broad terms. Right? So suppose a process of preparation of tea. I am claiming a process for preparation of tea. Now, it is not clear whether it is, I can prepare any other beverage. So it comes to my mind, why should I use tea? I should use beverage. But I have prepared tea, so I try to make it as broad as possible. So I claim a method of preparation of a hot beverage. Oh, then again come to my mind, oh, it's not clear whether it's a plant beverage or non-plant beverage. So, okay, tea is a plant beverage. So it's a process of preparation of a hot plant beverage. But still, it's hot or cold, plant or non-plant based. They are limiting factors, remove it. It's a method of a process of preparation of a beverage. Broad claim. So what you are trying to claim, it's a process for preparation of a beverage. This is your first independent claim. Now you claim your invention, the best method known to you. And that is, as claimed in claim 1, the beverage is hot beverage. It is a plant beverage. It is in this manner prepared. So meaning thereby, when you try to write claims, first claim should be the broadest claim, devoid of any limitation. You have a horn used in the vehicle. Okay? So what you claim? You are claiming a horn for vehicle to put in the motorcycle. The purpose is, what is the purpose of horn in the motorcycle? It signals to whom? The person in front of you to get aside, right? The purpose of horn is to give signal. I can use that horn in the motorcycle that you have used for other purposes also. So I installed it in the building. If there is any casualty, if there is any fire, if there is any emergency, I'll blow the horn. The horn will blow, and you get the notion that, okay, fine, I have to rush back. Some emergency is there. I have been called. There is a casualty, anything. Okay? So what is the purpose of horn here is? Signal. Right? So though you have invented a horn to be used in the motorcycle, don't claim that. Remove limitation. First claim is a signaling device. A signaling device as claim 1, and one of the method of signaling device is a pressure horn. Okay? It's a signaling device. That device can work with the pressing the button, or you can use your phone by as previous, but so anything is possible, but the idea of invention is a signaling device which uses. You have used electric motor in invention. So suppose there is a device which works with electricity. Don't claim electric motor. Limit your invention. Instead of calling electricity, it's source. Electricity, it may be from atomic energy. But it's a power source from which you derive the power. Okay? Try to be as broad as possible. Then in independent, after independent first claim, you write dependent claims dependent upon the first, and then you try to include those limitations which you have removed. Are you getting it? So first, to write the independent first claim, write your invention, what you have claimed, your embodiment, in the limited manner that you know. Try to remove the limitations, make it as broad as possible. That is your first claim. Then try to include those limitations which you have removed. So as claimed in claim 1, the power source may be electric. As claimed in claim 1 or 2, other device. But now you install that particular thing in that independent claim. So there are main claims, independent claims, then there are sub-claims which are dependent on the independent claim. So you write these claim sets. Yes. So though claim comes at the last, But the practical thing is, try to write the claim first. So once you understood invention, this is the prior art, this was the problem, this is the new thing that I've invented, this is my invention, I want claim. Whatever you have, what is your invention, your intellectual ingenuity, write a claim for it. So claims are generally the first to be written. Forget title, forget everything, claim. In the claim, try to build your whole specification around it. What you have claimed must be in the specification. What is in the specification must be in the claim. Write specification, revisit. Whether you have, whatever you have described has been claimed, and whatever has been claimed has been described. Okay? Then write everything, title will come. So claims, application, your specification may be used for the purpose of interpretation, but you will only get protection, legal protection for the claims. You cannot say, I forget to claim, though I have specified in the drawings or in the specification. Okay? If you have described it, you have diverged it, not claimed, it stands disclaimed. You cannot claim it later on. So, and you see that the terms have been appropriately described and disclosed. You're a lexicographer, you can coin the terms, you can coin new phrases, but their phrases must be used homogeneously throughout the application. You cannot say nail at one point and fastening medium at other point. It must be similar. Anything not claimed stands disclaimed. Yes, this is one example. So you have invented a chair with the 4 legs. This is your embodiment. But if you claim, what is a chair? A chair is basically a seat piece which has been attached with certain embodiment and which make you sit not at the floor but something which is on the, over and above the floor. So you have used in your invention a chair, but if you claim chair leg, you will lose protection for this type of invention, this invention. Because your idea is you want some can sit some embodiment which make you not on the floor. So what is it? And what is your leg piece? It is a member which engages the seat piece with the floor. Say it a floor engaging member. Independent claim. Then in your dependent claims that the seat will attach to the first layer check, which is but one example of the floor. This is the best method known to you. You have to claim it as well as describe it. The best method known to you. Then the last is the abstract. Now, abstract is basically how different from summary? Summary is the summarization of your whole invention, description, etc. in very concise form. So that one can understand that what was the prior art, what was the problem, what solution you have provided, in what manner it functions. Abstract is basically talks about the technical aspect of invention. We are not concerned about what was the prior art, what problem was there. What you have invented, that must be in the abstract. Your technical aspect of the invention, and this must be written in not more than 150 words. And abstracts are basically used for the purpose of searching. So as I told you, when you give some catchwords to the search engine, you'll be bombarded with, say, 100 documents relevant to your invention. Each patent application, patent document runs into, say, 50 pages. So you have to go through 50 into 100. It's a time-taking process. So instead of going through the whole document, you can only go through 150 words abstract which talks about the technical aspect of the invention, and you can be sure of that whether your technical aspect coincides with the prior art or not, or it is different in what manner, so that you can understand what is the scope of your invention. Clear? So abstracts are generally used for the purpose of searching, and just to go the cursory look, you can get the gist of invention, the technical aspect of it, because that is the aspect for which you can get the patent. Clear? So it is used for searching, as I told you. So the process again, just to revise, it's first the filing. You have filed an application with the patent office. Then it will be published after 18 months, if not previously requested. Then there has to be a request for examination. You send a request to the patent office that your application may kindly be examined within 48 months of your filing. So if within 48 months you have not filed the request for examination, after 48 months your application will be deemed to be abandoned. It is dead for all purposes now. Okay. Then examiner will send the first examination report within 12 months to you. Then you set the response. If everything falls in line, you may be given a hearing, and then you will be either granted the patent or your patent application will be denied. Right? So this is the whole process of patent application. Thank you very much. Any question? I'm open to queries. If you have anything in your mind. Yeah, you can just.
So thank you so much, sir, for explaining the technicalities of patent, that is the parameters, due procedures, the pros and cons of provisional specifications, the detailed description of invention, and others. Now, I would like to request our HOD, sir, to please come on stage and present shawl and memento as a token of respect.
Thank you, sir. That was a very wonderful session. As we have discussed about overview on IPR as well as drafting of patent, it's time to discuss about management of IPR. Intellectual property rights management involves the strategic handling of intellectual property assets to maximize their value and protection. It encompasses identifying, acquiring, protecting, enforcing, and leveraging intellectual property rights such as patents, trademarks, copyrights, and trade secrets. Effective IPR management helps businesses safeguard their innovations, build competitive advantage, generate revenue through licensing or sales, and maintain market position. It also involves risk assessment, legal compliance, and alignment with business objectives to ensure the efficient and effective utilization of intellectual property assets. To delve more in this particular field, I would like to introduce Dr. Vijay Pal Singh.
Dr. Vijay Pal Singh is currently an associate professor of legal management at IIM Lucknow and has more than 10 years of teaching and research experience. His area of research and interest includes IPR laws, business laws, cyber laws, including cybercrime, competition laws, and consumer protection laws and human rights. He has published various research papers in edited volumes and journals of repute, and has participated and presented papers in several national and international seminar, conferences, and workshops. So please give a round of applause.
So, very good afternoon. The persons present here and those who are not present here. When I was sitting here at the chair, I was thinking that what should I say? And then I had a story in my mind, which I read long back before, that there was a king and he was going to get married the third time. And every person was happy in his kingdom except himself. He was being very nervous. The reason was that in two marriages he performed well. And he was worried whether he will be in the third or not. And that is the case with me after Professor Bhatti, after Professor Manish, whether I will be here to tell you anything about this subject. I don't think so. If any question, please go to them. Right? So, a lot of things about intellectual property rights. So, intellectual property rights is nothing but it is the creation of mind. And when you create anything, when you get your ideas, what is required is that you should protect the ideas. And the very first thing is that ideas cannot be protected. It is the expression of ideas that can be protected. And when you express that very thing, then you own certain property, and that is known as intellectual property, which can be protected by different IPR laws. So, intellectual property refers to the creation of intellect for which the domination is assigned to the designated owner by law, and it refers to creation of mind with moral and commercial values, such as inventions, literary and artistic work, symbols, names, images, which are used in commercial world. So different aspects of IPR, patent, industrial design, trademarks, plant variety, geographical indication, trade secret, copyright, everything was well explained and discussed by Professor Bhatti. Therefore, I need not have to say anything. Because I have a slide, therefore I'm going to say something. Right? Copyright protects someone who creates an original work. Literature, drama, music, art, motion pictures, sound recording is protected by copyright. When we talk about patents, a patent is a limited right granted by government that allows the inventor to stop others from using or selling that very specific invention. This very right is for limited period of time, that is 20 years. And for getting patent your invention, what is required is that there should be novelty, there should be non-obviousness, and it should have some industrial utility or applicability. When we talk about the third, that is the trademark, trademark tells you the source of very product. It also a relationship between the brand and the consumer. For example, all of you who are sitting here in this very auditorium must be eating ice cream, right? And there is an ice cream that is Quality Walls. How many of you know that which company owns Quality Walls? Yes. So out of that, 2 or 3, 4 persons knows. So it is the relationship, or it creates the relation, the trademark creates the relation with the product and the consumer, and consumer distinguishes that very product. He is nowhere concerned with which company makes that very product, which company owns that very product, but he distinguishes that very product, he relates that very product with that very trademark. Again, it is for 10 years. You can renew it after 10 years. IPR compensates for the time, efforts, resources that these creative individuals would have invested towards such creation by protecting their intellectual creations. And today, in the present era, all that is as a knowledge economy, and there is boom of information technology, and in this very era, IPR have taken the center stage in protecting the intellectual creation of creative person. IPR have become a critical element of a business organization, as most of its values comes from intangible assets rather than tangible assets. Earlier we used to say that a company or a world which have, or a country which have the oil resources is the country which is a rich country. Nowadays, if you have a knowledge resource, you are a rich country. And from where knowledge will come? From your creativity of now. And when we talk about the creativity, there is IP, that is intellectual property. So having acquired these intellectual property rights, the business organizations must manage these rights efficiently to generate wealth for the organization and its shareholders. Reason being that business organizations are here to gain profit, not to do any philanthropic work. The shareholders do invest in the company to get the profit, and it is therefore the responsibility of a business organization that if they have IP, they should utilize it in profiting and thus gaining to the shareholders. And moreover, it is not only the case that if you have an IP with you, you have licensed it, or you can say that you have protected it through patent, through trademark, and you are not utilizing it for economy, then it is worthless. It is just storing it, and not using it. And if you are not using it or utilizing it, then it is not going to give you anything. The first story is related to Marshall Phillips. He was related to the company IBM. He was responsible for institutionalizing the process of managing IPR at the two largest companies in the world, that is IBM and Microsoft. He worked in IBM for about 28 years, and thereafter when he got retired, at the request of Bill Gates, he joined Microsoft. When he took over the IBM's IP portfolio, the company was in very bad shape in relation to the financial conditions, and over next 2 years, it suffered the loss totaling of 15.4 billion. And the sales from its flagship mainframe, that is ThinkPad, were down by 50%. In 1991, he became the vice president of the commercial and industrial relation at IBM. This very division of IBM was responsible for intellectual property portfolio, among other duties. As soon as he took this very position of vice president, what he did was he first changed the name of that division. So changing of the name do some work, right? So he changed the name of this division and stated that this division will be known as Intellectual Property and Licensing, and shut down its industrial relation and other programs. With this shutting down, he also did one thing, that he laid off 100 people from that division. After clearing the dead wood, he started analyzing the economies of the company's research and development and its relation to patent efforts. And he found that while the company was spending more and more every year on research and development, the company was filing fewer patents to protect that research and development investment. So his first important decision was to get the company to start patenting aggressively, driven by the of becoming #1 in US patenting. And he achieved this goal by 1993. He was appointed at the position in 1991, and by 1993, this company became #1 in terms of patenting license in United States. And since then, it is #1. He realized that filing patent is an expensive proposition. If you are filing, you are spending certain amount of money. And if you are not gaining anything, it is worthless. So based on the economic analysis, he found that this very division cannot operate as a cost center and has to become a profit center. For that, he decided to license IPR, which would generate royalties from the companies that used IBM technology. However, other divisions within IBM were to help him. So what he decided that the only way to get the divisions to support his activities was to share the royalty proceeds with them. You come with us, we will file the license, we will do everything, and we are going to share the profit with you. And during that very period of time, in 60s, in 70s, in 80s, and early 90s, one should remember that it was considered impious to even think about licensing your patent to others, including your competitors. At this time, patents were considered, or IP was considered, as a family jewel that were to be safeguarded as treasures, not to be shown or shared with others. But he somehow managed, and to prove his idea, he wanted a guinea pig to do an experiment on it. So what he did, an experimental model that could be used to prove the worthiness of his idea, he contacted Mike Atado, the microelectronics division chief, who was also struggling. Because there was a transition of bipolar to complementary metal oxide semiconductor chip technology. He proposed to Mike, he lent him 10 bipolar engineers, and most of them those who are going to be laid off. and some equipments, microscope, tunneling microscope, and scanning devices. In turn, he promised Mike that he would help him to earn $25 million for the division. Though initially Mike was skeptical, but later on he saw no risk and said that, okay, I'm going with you. And he lent 10 engineers with certain equipments. Equipped with necessary tools, Marshall Phillips asked those engineers to analyze the chip manufactured by the IBM's competitors. Discovered that in several cases, competitors were copying technology without its permission. So Marshall Phillips visited each of those competitors equipped with the relevant research data for their chips. During the meeting, he would ask those competitors' team to explain the chip looked exactly like that of the IBM. And there was pin drop silence. No person was able to explain, reason being that they haven't invented, they just took and used it. And thereafter, he used to explain how that very chip was manufactured, produced, and said that you have copied this idea and this technology was patented with us. And thereafter, what he did, he insisted those competitors to license the technology from IBM and other technology they might need to implement better. In this way, within a year, Marshall Phillips ensured that microelectronics division earned $40 million, 40. As a corporate president, he never sued the company for not taking licenses. And mind you, he was an attorney in that very company in 1960s. When that IBM was facing antitrust issue, he was the person who took out this company from there. And his success mantra was, if more companies their IP primarily as a business and financial assets and not a litigation club for awards out of rivals, the world would be a lot. Now, the word of success of the microelectronics division is regions. To with intellectual property and licensing division to get their technology licensed as well. While there was a lot of success with divisions, various divisions, there was much from other divisions or some divisions, and especially from the sales division. And the reason was that competitors to the technology they used to call through the sales division, they are going to cancel the orders, and sometimes they directly call to the CEO of that very IBM. And as a result thereof, there was a meeting fixed between CEO and Marshall Phillips. And thereafter, what happened in that meeting? CEO asked Mr. Phillips that why was he licensing the patents of IBM instead of using them to stop the competitors in their track? Do not give the authority to them to use it, file the case against them. So he said that, or he explained to his CEO that the whole world is interdependent and every one of them has to rely on the technology of others to work efficiently. And to prove himself and to prove his idea and to make the CEO understand what he did was he acquired an old IBM ThinkPad and started each of each item by pick. Started marking each item by using that the IBM had licensed from. He kept it up to maybe around 150 on the laptop and out of his to paste another toothpaste. He showed the laptop with all the toothpicks to the CEO and told him that the laptop ThinkPad, which they say that they have manufactured, cannot without technology, without using the technology of the others. And he, in that very meeting, also ensured to the CEO that given some authorities, would earn $1 million within years. And this very meeting was in the year 1993 and last in the year 2000. However, you can say that this very particular CEO stated that, okay, I'm giving you free hand. He advised all the खाना तैयार हो गया अच्छा इनकी हमसे क्या बीच में हम ला दिया So he said that given a free hand authority, he can earn $1 billion for 7 years. He was given that authority, and based on the licensing status, he was able to fulfill his promise of earning $1 million, not in 7 years, but in 3 years. And overall, he had spent around $36 million to run the for years. He did not technique. He did not invent any licensing technique. Licensing present day IBM, the technology in that very particular arena, time, use that very licensing strategy. You can call it a strategy, you can call it as a business strategy. He could have very much filed the case against those, can have a case against those, would have got what he in 7 years. But then what would happen? There would be a clash between the competitors. There would be, or you can say that that very particular phase in which IBM cannot afford. Reason being that the lawyers are there, they will charge money. You will have to contact with the technical and then it will take number from lower court to higher court to the highest court. So whether you have to file a case against your competitor, you have to file that very person or not, depends upon the situation in which a business organization is. Whether you will gain certain thing by negotiation or filing a case is there, and you have it by your own. So if you file a case, you can gain a lot also, provided you are in such. So Kodak did not pay much attention to the cluster of patents, 10 Polaroid patents relating to the integral instant camera technology, and which a small Polaroid has accumulated. Kodak launched a new line of instant camera and film products in 1975. Polaroid Corporation launched a patent infringement suit against Kodak, and after a long, that is 14 years battle, the court ruled in favor of Polaroid. A staggering blow. Kodak had to pay Polaroid US $92.5 million in damages, close down its 1.5 billion manufacturing plants, and buy back the 16 million cameras it had sold to customers between 1976 to 1985. Kodak had to pay $100 million for legal fees. Kodak had to write off 10 years of R&D expenditure for the development of its infringing products, and the IP ignorance and device implication. So you have to respect the property, and if you are utilizing the property of the other, get it licensed. Get it their consent for it. Otherwise, you will be in bad shape. So litigation is not always fine enough. Negotiation can do well. Sometimes if negotiation not, go for litigation. But if you are going for litigation, make sure IP fort has no chinks in it. जब भी आप किसी से फाइट करने चाहते हो तो आप को स्ट्रांग रखिए, अपने आप को स्ट्रांग रखेंगे तभी होगा, कहीं भी लीकेज होगा. And third case, Cadbury's Eclairs changed its trademark Eclairs to Chocolates. The Cadbury is a confectionery company. They manufacture chocolates brands and other products. For example, Dairy Milk, 5-Star, Bonvita. Of the sales representative of the companies came across a product sold by ITC under Candyman chocolates. The product had identical purple and golden color wrappers. It also had the same getup and layout in respect of its mark as Cadbury's, and the manner of writing the words Candyman and Eclairs was also identical, deceptively similar to the Cadbury's. On additional inquiries, that sales representative found that toffees were being sold in a jar by the same vendor in the same parent jar provided by the Cadbury, and children and adults alike. Refer to the legal team and their research. To further inquiry, ITC's website 004 Cadbury that ITC launched the Eclairs toffee in the year 2003 with an orange and golden wrapper, but later color scheme to mimic the dress of Cadbury's Eclairs. Cadbury approached the court against the ITC. to prevent ITC from selling the candy clears. The court considered the evidence presented by Cadbury's regarding the color combination and felt that ITC was deliberately taking advantage of the unique colors adopted and was reaping unjust enrichment at the cost of Cadbury's. What happened? Intellectual Property Appellate Board ordered the removal of 3 trademarks of Cadbury's eclairs following a case initiated by its rival company ITC. The case would have ended happily for Cadbury's if the matter had died down there or here. But upset by the Cadbury's case, ITC Intellectual Property Appellate Board against the Cadbury's 4 trademarks from the ITC claimed that though the Cadbury's had registered the trademark long back in 1972, they have not been using it in its commercial activities, because of which the 4 trademarks are liable to be removed from the registry under the provision of Section 47 of the provision of Section 47 states who are not using it, registered therein, to be removed after 5 years, if that very duration is 5 years. Filing its counter-argument, Cadbury's responded that it has been using the continuously, and it presents of its custom records and excise records. Of these records proved that company had used the trademark in the form it had registered, hence these pieces of evidence were set aside. And they were anyhow, and there is no reason evidence as Cadbury's was conclusive evidence on this. It said that it would like to withdraw its statement and would not contest ITC, and perhaps they must be thinking that if they are, ITC is also going to withdraw the application for the removal of that very particular trademarks. But ITC in its stand proceeded with the application for the removal of the marks from the registry. Appellate board the 4 trademarks registered with the registrar of the trademark. It found that 1 trademark was not renewed, because of which it had been removed from the registry. For the remaining 3 trademarks, the board felt that the Cadbury's was not able to present the evidence of its continuous use of the products, and it ordered the registrar of the trademark to remove them from the registry of the trademark. Thus, what started as a simple trademark infringement suit filed by the Cadbury's against ITC resulted in Cadbury's trademark registration being cancelled and the registrar of, and after losing to retain its eclipse, I call it as what Cadbury's did, they rebranded it and stated that instead of eclairs, they are going to write choco eclairs. And now we have choco eclairs. And from nowhere to everywhere. The best example, J.K. Rowling's. It is not only the trademark, it is not only the patent which can make you rich, it is also the copyright which can make you rich. And usage of other trademarks, usage of other IPs. J.K. Rowling, author of Harry Potter, number of series, Copyright, huge amount of money. In 1995, Rowling finished her manuscript from Harry Potter and the Philosopher's Stone on the old manual typewriter. She went to 12 publishing houses, rejected the last one, signed it and published it. 1,000 copies were printed, 500 was given to the libraries, and after 5 months, she got the first prize. The first award, Nestle Smarties Book Prize. In February next year, she got another prize, British Book Award for Children's Book, and later on she got Children's Book Award. In 2004, Forbes named Rowling as the 1,062nd richest person in the world. However, in 2020, Forbes removed Rowling from the rich list. Her 160 million in donation meant she is no a billionaire. Harry Potter, one of the richest literary authors, into 65 languages worldwide. Her Harry Potter book have been made into movies by Warner Brothers. Lot of money. The first film, Harry Potter and the Philosopher's Stone, ranked 4th on the worldwide list of all-time highest gross films. When ABC television broadcasted this film, they were able to still net out near about 4.5 million viewers. Haunting music, soundtracks composed by John Williams was sold near about 1.5 million copies in only US. It has been licensed to Lego Toys, which brought 53 sets. Mattel acquired the right to make Harry Potter action figures, games and puzzles. Electronic Arts got the license or took the license to manufacture Harry Potter computers and video games. Universal Studios and Warner Brothers have jointly established Wizarding World Harry Potter in Japan and in Hollywood. But not only this, related movies have been successful. These merchandising activities provided additional revenues to the authors, ensuring her a slot in Forbes' richest person between 2008 and 2012. What is required is that if you are creative, you have in mind how you are to manage the IP, huge amount of money. So arrangement, either in the form of licensing of the copyright or in the form of business, commercialize the copyright of the characters, and Rowling has been able from her copyright. Everything that is her creative content she developed. By resorting to such business models or transactions, she has successfully commercialized her copyright and earned revenues from her copyright and creative abilities. So what is required is that how you are going to manage your copyright, your IP. The very first framework or the very framework which I put in 1 minute is ER framework. Create, extract value, and reinvent. Create that thing, have expression of it, invent it, secure it through patenting, copyright, trademark registration, and they extract value from it. When the time period is going to be end, what you require to do is that time period ends, you modify it or you do reinvent, and whatever from after securing your product, invest in R&D, and again this very circle will. That is for example, Thomas Alva Edison sold his first invention, non-patented stock quotation printer, for £40,000. He used his money to start a lab, led 1,093 patented inventions, installation of the world's first central electric power in New York by General Electric today we have. Thank you. And for questions, my professors are there, along with a lawyer is there.
Sir, for your enlightening words, as you have told about how the idea of life formed and how much impact it continues to hold in the interplay of negotiation and litigation, the various ITC, and how the idea of copyright and generate such a financial. Now, I would like sir to please come on stage, present sir with a shawl and moment of respect to sir. Please give a round of applause.
अभी तक हमारे साथ आप सभी का जुड़ने के लिए बहुत बहुत धन्यवाद। अब समय हो गया एक छोटे से विराम का। सभी के भोजन का प्रबंध सभागार के सामने किया गया है। हमारी पुनः मुलाकात होगी 3 बजे। धन्यवाद।